Do you have, if we have to start bringing people out, do you have a partner or?
Yeah, I'm waiting on them. They should be here in a second. I let them know that you're on the bench. They were grabbing a key.
Okay.
We only have one that's in right now, though. We're still waiting on the other one's in ACDC. So Walker is the only.
Okay, thank you.
No problem.
That's my only one.
This was APD.
What's that?
This was APD.
Yeah, so EPP, had people, that's one thing. It's part of the.
I think it was just a joint, and that was the closest marked unit.
All right, why don't we get started? Good morning, Ms. Rivers. Are you able to hear us?
Morning, Judge. Yes, I am.
Great, okay. Nothing to take down right away. I just want to make sure we had a good audio connection. We have a series of calendars to work through. As I understand it, only 2 inmates. One is here, so Mr. Walker is here. So I don't see Ms. Willingham. So we may hold on taking. Are you going to be Ms. Willingham today?
I'm not, Judge. I can
All right.
talk to her.
Oh, that's all right. I'll call the final plea calendar and get through that. And we'll see how that goes. I got an email. Nope. Text. 8. Okay, we'll start with the final plea calendar. These cases are here for either a resolution on the last day that someone can resolve a case and withdraw his or her plea if dissatisfied with the outcome. Otherwise, we're moved to trial. And most of the cases on here are moving to the August calendar. A few of these are. Mr. Jordan's not here either. Are you Mr. Jordan?
I am going to be Mr. Jordan.
Okay, I got you for one of these. They relate to the Hill case. So anyway, let me call the calendar and we'll see where we go with that. We also have I think it's a plea with Mr. Walker.
Yes, Judge.
Okay, he is here. We just need Ms. Willingham. And then we have a probation revocation. And Ms. Rios, I think that's yours. And then it says Ms. Willingham on it. So maybe that's who we need, or are you handling that, Ms. Nix?
I believe that's,
Demario Williams.
yeah, that's Mr. Strip here this morning.
Oh, also, so you're not Ms. Willingham for the plea, but you are for the revocation.
I think for the revocation.
Okay.
Yes, that'll be me and Miss Nix, because I believe he also has a open drug case in complex.
Yes.
Okay, we'll figure it all out. Let's get moving through the calendar. So positions 1, 2, and 3 all involve Cameron Miller. Is Mr. Miller here? Just walked in.
Good morning, Judge.
Good morning, Ms. Rios. How are you?
Good. How are you?
All right. Remind me that we need to talk about Marcus Jackson at some point this morning.
Yes.
But right now we're talking about Cameron Miller, who's got 3 cases on here. Mr. Miller, I just explained before you walked in, this is the final plea date. It may be you're resolving your cases today. If you're not, the main thing that changes is that you lose your right to withdraw your guilty plea if, fast forward 2 months, and you say, I want to work these out, and then you don't like the sentence I give you. That's too bad then. But today, if I sentence you in a way that's different from what Ms. Rios advocates for, you'd be able to say, well, wait, what I had agreed to was X and you did X plus a little bit more. So I'd rather go to trial. But I don't know where we're going with this.
This will likely be a plea. I just have to talk to Ms. Nix about one condition.
Okay. And it would resolve all 3 of his cases?
Yes.
Okay. So Mr. Miller, you should take a seat. Ms. Rios is going to talk with you. She's going to talk with Ms. Nix. That's the prosecutor who is handling your 3 cases for the state. And maybe we'll be able to resolve all of them.
Yes, Your Honor. Thank you.
You're welcome. That gets us to Ms. Jackson. Is Ms. Jackson here or online? I don't see Mr. Luemba. I guess Ms. Nelson can reach out to him, but I remember talking with Ms. Jackson and she knew to be here. So we'll hold on this one. We are holding for Attorney Luemba is the note that I just got, but Ms. Jackson does need to be here. How about Mr. Walton? If he's one of the people online. Are we holding for Ms. Cabrera also? These are all from the same hill.
Judge, Ms. Cabrera is in Gwinnett County,
Okay.
and I believe she anticipates that case to be a plea. This is Dennis Francis.
Yes. Hello, Mr. Francis. I recognize the voice and the stack of books. Ms. Cabrera thinks her Gwinnett case is going to be a plea, or that Mr. Walton's case is going to be a plea?
Mr. Walton's case. She believes
Okay.
that's going to be a resolution. So she's
Okay.
going to log in very shortly.
Okay, great. Is Mr. Walton, you're not Mr. Jordan, I know, but we have one gentleman who was in Oregon in this case, and so maybe zooming in, and then we had one in Columbus who would drive up. That may be Mr. Walton. I'm not sure.
I'm actually not sure as well, Judge, but I
Okay.
can look through and see.
Okay, we'll see. I mean,
Addresses listed.
right now, Mr. Walton's not here, so we will see what we get. All right. Getting off. Oh, we have one more in that case. Brian Burnett.
Good morning, Judge.
Hey, Mr. Burnett, how are you?
Wonderful.
And your lawyer is Mr. Francis.
Right.
Little library scene. What are we doing today with Mr. Burnett, Mr. Francis?
I think we're going to further notice Mr. Burnett to the trial calendar
Okay. Let me,
to work on it.
okay. Let me look one thing up. Okay, I don't have a trial date for that one yet, but we'll figure that out. Mr. Burnett, I need to get a couple things on the record, so we're gonna have a quick conversation. Let me get you and Mr. Francis squarely on the screen. There you are. Oh, there's Ms. Cabrera. Where'd you go, Mr. Burnett?
I'm here.
Yeah. Well, I don't see you. There you are. All right. Great. Let's get on the record in 24 SC 000053. Mr. Francis, you are indicating that today is not a day that Mr. Burnett wants to resolve the case. He may want to go to trial, but regardless, it's not going to be a plea today. Do you feel that you've got all the discovery, or is that one of the issues here?
No, I think we're complete.
Okay. Mr. Shapiro, if Mr. Burnett wanted to resolve the case today, like some of the other defendants have in the case, what would the state be recommending?
Judge, my understanding is that the offer that was extended by ADA Jordan for Mr. Burnett was a plea to misdemeanor, simple battery, and 12 months probation with a condition of no further contact with the victim.
Okay, so there were two victims in the case, a little girl and a little boy. Is it, I don't know if Mr. Burnett is associated just with the female or the male, do you know?
So Mr. Burnett is charged with physical abuse against the young girl.
Okay, and so it would be no contact with that individual for the 12 months?
That's correct, Judge.
Okay, all right. Mr. Burnett, do you feel like you understand if you went forward with a plea, what that would look like today? You're charged with a felony right now, cruelty to children in the first degree. The state is willing today to reduce that to a misdemeanor. And if you wanted to go forward, the state would be recommending 12 months of probation as a misdemeanor. Do you understand that?
Yes, sir.
Okay. Is that something you are interested in pursuing today?
Yes, sir, I am.
All right, Mr. Francis, you want to have a conversation with Mr. Burnett offline?
Yes, that's fine. Because I didn't receive that offer. Yeah, well, I will talk.
This just in, it is how a couple of the other defendants have resolved the case since Ms. Hill, April Hill, pled, and then things began to be shaped like what you just heard Mr.
Okay.
Shapiro say. So why don't you
Fantastic.
two, I can either put you in a breakout room or you can drop off and talk. How do you want to do it?
Breakout room would be great.
All right, Mr. Burnett, I'm going to move you and Mr. Francis into a Zoom space that's private. I can't hear you. The prosecutor can't hear you. When you guys are done talking, you can pop back into this room, and it may be that we resolve your case today and you'll be finished, okay?
Yes, sir.
All right, hold on.
And Judge, while Mr. Francis and Mr. Burnett are speaking, I'm going to step out to make sure that wasn't miscommunicated to me. And
Okay, that's my understanding. I think you are relaying the way in which Mr. Jordan was approaching all the other defendants, having resolved Marquise Hill and April Hill.
that was my understanding.
But why don't you double check? But that's consistent with what I've heard Mr. Jordan tell several of the other lawyers in the mix.
Okay, thank you, Judge.
All right, let me get that breakout room going.
Mhm.
All right, you should be able to join the room. Yep, oh, we got done. Okay. All right. Let's keep going through the calendar. After that case, we get to Shantarian Cosby.
She's present, Judge.
Oh, Ms. Cosby?
A plea today. I just need to speak with her out in the hallway and then we'll be ready.
Got it. Ms. Cosby, Ms. Wood's going to talk with you, and it sounds like we're resolving your case today, okay? Zaquan Franklin.
He's present, Judge. I'm doing some begging this morning.
So keep it open for right now? All right, begging, I'll write that down. All right, Mr. Franklin, your lawyer's right next to you. He's going to tell you what's going on. You heard me explain to Mr. Burnett over the Zoom, if you don't resolve your case today, the right that you forfeit or give up is the ability to back out of the plea if you don't like the sentence that I impose. Otherwise, you can always resolve your case tomorrow, next month, whenever. All right? And finally, Mr. Lara. Mr. Lara was not brought over. His situation is still pending. And so we'll see what those results are. So we will further notice this, maybe do an inquiry. And you all got my email. There is a case, I don't know which of the public defenders would have received it, a female that is going straight to the competency docket. We won't even do the plea and arraignment. So.
Judge, do we need to do a final plea hearing on Mr. Franklin?
We do, but the way I understood it from Mr. Smith is that he's going to want to talk with you more before we do that.
Oh, okay.
So I'm not skipping that. I'm circling back in the same way we're circling back to Ms. Cosby. Sounds like it'll be a plea. But that's where we are on that one. Walker is a plea, and then Ms. Willingham is here. Good morning.
Good morning.
I think you have a probation revocation and then the plea with Mr. Walker. You're surprised by one of them?
I am, not by Mr. Walker.
There is a Demario Williams, and it may be that,
That was never, I'm sorry, Judge. That was never Miss Willingham. That was always Mr. Jordan.
oh, always Mr. Jordan.
I don't know why Miss Willingham's name got put on it, but
Okay.
that was always Mr. Jordan.
Just like sharing the cases. Okay, and so it's going to be Mr. Shapiro.
Yes, Judge.
Got it. All right. And Mr. Williams would be, I guess, our other inmate who is inbound from the city jail and is not here yet.
Actually, I just sent the sergeant went downstairs to grab, so it should be.
He's here.
About 5.
Great. Okay. I'm fine doing the Walker plea since Ms. Willingham is here now and he's in custody. And that will free up Ms. Nix to have to deal with Mr. Smith's entreaties. And I think that's it. We have an interpreter here, and I'm wondering what that's for. There was for a while on the call, Mr. Marquez, But I don't know what that is. That's not on any of these calendars.
It's a add-on, off calendar matter, Judge. I can give you the case number,
Please.
23 SC 191184.
Okay.
This is Jamie Maldonado.
It's not Mr. Marquez?
Well, I may be wrong. I think he has multiple last names.
Okay.
I've just been referring it to Maldonado.
Okay.
This is one, I just sent Mr. Shapiro an email. Mr. Jordan and I have been talking about this one.
Mhm.
I'm hoping to resolve this one today.
Okay. So Mr. Shapiro will need a little time to get up to speed on it, but we do have Mr. Maldonado and he requires, this is why we have the interpreter.
Yes.
So let's prioritize that. We can do the Wilson plea while Mr. Shapiro's getting up to speed. It's this, both names are in there. It's Jaime Ramon Marquez Maldonado. So we're talking about the same person. There was a judicial hold in place. He has a warrant?
There's a
Okay.
warrant, Judge, yes.
Oh, okay. All right. Let's see if we can get, he is right now, there's no audio. Can you ask him to turn the audio on, please?
Yes, Your Honor. Where do you want me to stand?
You can be right up at the podium.
Okay.
Thank you.
Señor Maldonado, tiene que prender su micrófono para que le podamos oír, porque no está prendido su micrófono. Sí, conéctese al audio.
Looks like he's trying.
Right. Let's see.
While we're waiting on that, we're gonna, oh, he's connected. All right. Can you ask him if he needs your services?
Señor Márquez,
Sí.
yes. ¿Va a necesitar el servicio de la intérprete en español?
Okay.
Le estoy preguntando.
Sí.
Are you going to need the Spanish interpreter? Yes.
Okay. All right. If you could explain to him that we hope to resolve his case today, but the lawyer needs a few more minutes.
Esperamos resolver su caso el día de hoy, pero el abogado o la abogada necesita unos cuantos minutos más.
Okay.
Ok.
Is he able to stay on the call?
¿Puede permanecer en la llamada?
Sí.
Yes.
Okay. All right. Then he can go back on mute and we will get to him as soon as we can.
Se puede poner de nuevo en mudo al micrófono y vamos a regresar con usted en un momento.
Sí.
Yes.
Great. Are you able to stay for a little bit?
Yes.
Okay. As
Yes,
soon as if they're going to sort it out, we'll jump to that one. So
That's
we
fine.
don't keep you here.
Thank you.
Sure.
And she's like, oh, well, you know.
Good morning, Ms. Cabrera. How are you?
I'm wonderful, Judge. How are you?
I'm well. I see Mr. Walton joined us.
Yes. He has a
Is
misdemeanor plea.
okay, great. We will take that in a moment. We're going to take a plea with Mr. Walker, and then we can pivot back. If the Marquez case is ready, we'll do that. If not, then it sounds like Ms. Cabrera and Mr. Walton are ready to go from the other case.
And Judge, I was going to ask if I can, I do need to be in Judge Ingram's courtroom at 9:30 for what should be a very quick case management announcement. So if I can run down there while we're doing this plea and try to get that announcement done, I'll then come right back up.
Sure. I'll tell her to let you cut in line.
I appreciate it, Judge.
All right. Can we bring Mr. Walker out, please?
fine.
If you have any questions, just stop me and we'll step in the back, okay? It's the same thing we talked about in jail.
Yeah, man.
1 second.
Our internet just stopped working. Do you by chance have?
Yes. There you go. You're welcome.
All right, Ms. Rivers, are you ready?
Yes, I am.
We're gonna go on the record in State versus Omari Walker. It's 23 SC 186-205. Mr. Walker, good morning.
Good morning, sir.
You are here because Ms. Wood tells me you're prepared to enter a plea in your case. Is that correct?
Yes, sir.
All right. Ms. Willingham, we'll be putting you under oath in just a moment, asking you a bunch of questions. None of those questions should be a surprise, but if at any point during our conversation, you've got a question, will you let me know?
Yes, sir.
All right. Ms. Willingham, when you're ready.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your name and your age.
Omari Walker, 26.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
11th grade.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case is that you would be entering a plea of guilty to count 1, arson in the first degree with a sentence of 3 years probation. Count 2 would be null pros, and you would be entering a plea to counts 3 and 4. Count 3 is battery, family violence, and count 4 is criminal damage in the
Second degree.
Oh, I was just making sure.
Okay.
And both of those counts, it would be 12 months probation, and they would run concurrent with count 1. And I guess for count 4 would be 1 year, because that's a felony.
It's a felony,
Yes.
right? Okay, overall then a 3-year probated sentence is the recommendation.
Correct.
Okay,
You would have no violent contact with the victim, complete family violence intervention program, complete 100 hours of community service. Is this what was explained to you by your lawyer?
Yes, ma'am.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
Yes, ma'am.
you say yes?
Yes.
Okay, what, are you on
I just
parole or
am.
probation?
Probation. I just came from Douglas County. I was incarcerated there for 12 months before I came here.
Okay,
So I took 7 years probation there. I wanted to know if I take this probation, would it be ran concurrent? Because I was already supposed to be checking in Fulton County.
it'll all be supervised in the same place. We've got a probation officer on the call who will talk to you about how that's going to work, but you are supervised based on your county of residence. So you might have 4 cases for which you're on probation, 1 from Rockdale, 1 from Cobb, 1 from Clayton, Douglas, and then 1 from Fulton. But if you live in Fulton, you're not having to report in all those different counties. You'll report in Fulton County, and your officer will be supervising you as to all those cases. Now, I hope this doesn't happen, but 6 months from now, you set fire to another car and get in trouble, you'll have those new charges. Douglas will want to see you again. You actually would go to Douglas County for the revocation hearing, even though you're supervised here. Does that make sense?
Yes, sir. I understand.
Okay, but you're not setting fire to any more cars? No? Okay, good.
You heard me tell the court what the negotiation is in this case, which is 3 years probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Under the special conditions, as discussed, you would be required to have no violent contact with the victim, complete the family violence intervention program, and complete 100 hours of community service. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am. Yes, ma'am.
Do you
Can I
have
ask a
any?
question?
I'm sorry.
Can I ask a question?
Yeah.
So if I the revocation, if I do that here, that would be the same for both counties, right?
We're doing a revocation here?
No, I'm saying, say for instance, if I were to not follow the things you told me to do in
Sure.
this county, will I have to go to both counties still?
Both counties, because you've got cases in both jurisdictions, and you may have, I don't know what your situation was in Douglas County. Make up a scenario. Let's say your Douglas County case was you broke into someone's house, so it's a burglary, and they give you that probation. If what you get in trouble again for is another burglary, that would be your first burglary in Fulton, and so the judge here might say, I'm going to revoke 6 months. The judge in Douglas might say, here you go again with another burglary. I think that's pretty serious. I'm going to revoke 2 years. So you could have different revocations. That being said, usually one circuit looks at what happened in the other and say, if you got 6 months, we'll run 6 months concurrently. But you need to understand there's no guarantee. Whatever judge you pled guilty to in Douglas County is the one who would decide if you get in trouble again. Of course, the solution is don't get in trouble again. But that's more on you than anyone else.
Understood.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I have asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offenses to which you're pleading guilty?
Yeah. Yes. Yeah.
You have to answer.
Yes.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered for felony offenses, and for the misdemeanor offense, you will have 12 months from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, ma'am.
Should this case proceed to trial, the state would prove beyond a reasonable doubt that on July 23rd, 2021, officers responded to 2764 Landrum Drive, Southwest Atlanta, Georgia, in reference to.
I've got a May 5th, 2020 date in the indictment.
Read the actual notes.
They may be related, but all this is at Stone Hogan Connector Southwest.
Correct, Judge. I'm just gonna flip to the police report.
Okay.
Okay. On May 5th, 2020, Officer R. Smith responded to 3000 Stone Hogan Con Southwest to apartment Q10 to a fight call. Upon arrival, officer spoke with the victim, Miss Alexander, who stated that the child of her father had beat her up and lit the inside of her vehicle on fire.
The father of her child, or I know you may have read what was there. Are you Do you share a child with Ms. Alexander or you are her kid?
No, I share a child.
Okay, got it.
Ms. Alexander stated her brother, Devontae Alexander, allows the suspect or Mr. Walker to stay at the above location. Ms. Alexander stated that she saw a notification on his phone and called Mr. Walker out for lying to her around 9 a.m. this morning. At that point, Ms. Alexander stated that Mr. Walker punched her in the face and then proceeded to grab her by the hair and drag her down the stairs. During the altercation, Ms. Alexander sustained a couple of lacerations to the top of her head, swelling, and a cut to her bottom lip, and approximately a 3-inch long cut to the left side of her chest. Ms. Alexander refused medical treatment. Ms. Alexander stated that she went to an interview and came back at 4 p.m. this evening. She stated that Mr. Walker had come back to the above location and began trying to kick in the door. Ms. Alexander would not let Mr. Walker back inside, and Mr. Walker proceeded over to Ms. Alexander's vehicle. Mr. Walker grabbed what is believed to be the bill of sale to the vehicle, proceeded to light it on fire, and put it inside of the vehicle. The vehicle's front right passenger seat was melted from Mr. Walker's actions. The vehicle is a 1993 Nissan Maxima. Ms. Alexander and her brother both observed Mr. Walker start the fire inside the vehicle from inside their home. Mr. Walker was no longer on scene when officers arrived. A warrant was subsequently taken out. And Your Honor, unfortunately, I can't pull my notes back up. I do know that I've spoken with Ms. Alexander regarding this case, and she's aware of the state's offer. Typically, I know I give more detail about what she said, but I can't see that at the moment.
Okay, no, I understand you're having technical difficulties. The part that I'd want to most understand is the no violent contact provision. It may be oftentimes Ms. Wood has had more contact with the victim than you. Because if it should be no contact, then I need to put that. I know they have a child together and that makes it complicated. But if Ms. Alexander, and I appreciate it's 4 years on now, is saying, I'm scared of the guy, I don't want to be around him, then I don't want to be putting in a no violent contact. So that's why your notes.
Yes.
Yeah.
I don't recall her. Typically, if I put no violent, it's because I've had that conversation. Unfortunately, I'm not comfortable saying for certain, but I can update the court. I'm hopeful it'll be back up shortly.
Okay.
So I can update the court as soon as possible, and I'll make sure I notify Ms. Wood as well.
Okay. All right. I think I follow that. Let me ask Ms. Jackson. Good morning, Ms. Jackson.
Good morning, Your Honor.
It's been a long time.
Yes, it has. It's been a while.
I appreciate you coming back to us. Can you share with me what you have for criminal history for Mr. Walker?
Yes, Your Honor. He has 12 cycles. The last arrest was October the 20th, 2023 in Douglas County for battery. There was no disposition for that arrest. He does appear to be on first offender probation in Douglas County for 2 counts of theft by receiving stolen property and possession of a firearm during commission of a felony and possession of Schedule 2 controlled substance and misdemeanor obstruction of an officer and possession and use of drug-related objects and possession of marijuana with the intent to distribute and possession of controlled substance with the intent to distribute. That disposition date was April the 17th, 2024, and the term is for 5 years. He does have 1 prior misdemeanor conviction that was in 2019 for simple battery. Nothing in addition, Your Honor.
Thank you so much. So, Mr. Walker, you heard Ms. Jackson describe the Douglas case. That's the one you're on probation for?
It's only 5 years.
Well, she's saying 5 years. We actually have a probation officer on the call, so shh.
That's true. That's true.
Okay. I mean, lower is better, but it's a brand new case. So you're on for a minute out of Douglas County, and more importantly, is longer than this one. And so if all goes well, this case will be shut down before the Douglas County case is shut down, because the recommendation here is 3 years probation. Let me hear from Ms. Wood.
Thank you, Judge. Mr. Walker's 26 years old. He is a lifelong Atlanta resident. He has an 11th grade education. He has 6 children. He was working for a cleaning service before he was locked up last year in Douglas County. Judge, since he did spend the last year in custody, I would ask if the court would waive probation fees for the first couple of months.
So, Mr. Walker, you've not been out yet? You did a year in Douglas and came straight here, or were you like out for 2 days?
No, I've been arrested the whole time. I got arrested last year on April 17th.
Okay, for whatever the stolen car, whatever the Douglas case is.
Fanny Luda was the case. The October 20th situation was a fight in the jail.
Okay, got it. In Douglas County.
Yes, sir.
And do you know if that case is still open?
I mean, obviously they just named it.
Well, that just means you got arrested for it.
I just bonded. I had to bond out for it to come over here, so I didn't
You
come
do?
until April 30th.
Okay, so you may have to go back to court in Douglas County. Don't miss your court date.
Yes, sir.
Okay. 6 kids. How many with Ms. Alexander?
Just one.
Just one. How old is your oldest kid?
9.
How old is your youngest kid?
4.
That's a bundle in that age. Okay. And Ms. Alexander, is that someone you still will be spending time with, or?
We have no I mean, we're very cordial, like we talk because we're parents or whatnot.
Okay, but your connection now is parents and not romance or business, or it's just, hey, we have a kid together and so we need to interact to.
She's trying to get married, so everything.
Oh, and not to you. Okay, all right. So she's out of the picture.
Yes,
She
sir.
better be. You may find your car on fire if you're messing around over
I
there.
go home.
Good. I bet you do. It's been a minute. Where's home for you?
And basically Campbellton Road.
Do you have a place you're going?
Yes, sir.
And who lives there?
Grandmother's house.
This is my godmother.
Oh.
You're gonna stay with your godmother?
Yeah, until I get my own spot.
Does she know that you might be there in the next couple days? Or is that gonna be a surprise? Like you knock on the door and she's like, who are you? Oh, I recognize the thing on your neck. You're my godson.
It's my birthday.
Okay, well, this is how she'll recognize it. She's like, isn't that your birthday? You must be my godson.
Yeah.
Does she know you're heading her way?
Yes, sir.
Like you've talked to her?
Yes, sir.
Okay, that's good. Do any of your kids live there?
No, sir.
Are all your kids in the Atlanta area?
Not all of them, no.
Where are those who are not in Atlanta? Are they in Georgia?
Yeah, all my kids in Georgia.
Okay,
Some in Villa Rica.
Okay.
Rome.
all right. No restitution to rebuild the melted front seat?
No, and I did, I was able to check my notes on Miss Nick's computer, and it looks like when I spoke with her, she did mention that she was getting married. She did not want to proceed forward, but she didn't know whether no contact would cause a issue for,
Parental visitation.
patients, and she didn't want that to be an issue.
Okay, we'll do no violent contact. I think Mr. Walker gets it that if there's an issue with Ms. Alexander, not only does he have to contend with the husband, but he'll be coming back here. And you should know, Mr. Walker, because you've been focused on it. Anything you do that gets you in trouble will ripple over into the Douglas case too. It wouldn't matter like, hey, but what I did was in Fulton County. Douglas doesn't care where it is. You could be in Villa Rica and make a mistake, and then you got to deal with Douglas and you got to deal with Fulton. Do you have any questions about anything we talked about?
When I do change my address, I contact my not public defender, but my probation officer, right?
Sure, it never hurts to tell your lawyer, but probation is your number one contact. And so you're going to get a probation officer, not the one who's on this phone call. She's going to give you reporting instructions because you're going to need to go to probation. It should probably say next 72 hours, or she may even give you a specific date. Don't miss that date because if you miss it, they sign a warrant. You're off to a great start. Doesn't get you in trouble in Douglas and here. But yeah, you're going to move. Right now, you're going to stay with your godmother. You're going to find your own spot. And you don't even need to move to Fulton. You could decide you're moving to Clayton or somewhere else. It doesn't have to be in Fulton. But when you do move, you got to let probation know because they need to be able to knock on your door to make sure everything is okay in your home situation. Okay? Don't be hard to find. That's the worst thing you could do other than set another car on fire while you're on probation. Okay? Yes?
Yeah.
Yeah, good. All right. Mr. Walker, I find there is a factual basis for your plea. I recognize that this conduct is now 4 years and almost 2 months old. It's just now catching up to you. And other than the situation in Douglas County, you seem to have kind of stayed out of trouble. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. And knowing means you understood all the stuff we were talking about. And if you didn't, you were very inquisitive and asked your questions. So do you feel like your plea was knowing and voluntary?
Yes, sir.
Great. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, in this case, if you have a small issue, maybe you miss a meeting with probation, something like that, you don't have to come see me. You'll work it out with probation. They may add some community service or do this or that. But if it's more serious, in particular, if you get arrested for anything, that comes back to me and we'll work through that situation. And as you've learned, you probably have to cycle over to Douglas County to work through it there. So best to stay out of as much trouble as you can. But life is complicated. Mr. Walker, I'm going to sentence you on count 1 to 3 years to serve 1 month with the balance probated. You've already done 53 days here in Fulton County. That's more than a month, so you've done your month. Count 2, the state has dismissed. Count 3 will be 1 month to serve, and count 4 will be 3 years to serve 1 month, balance probated. All those counts run concurrently. So you're actually serving 1 month less of probation than your lawyer asked for, because I'm giving you credit for the 30 days plus that you were in custody. Special condition of probation number 1. This is important. It's the Family Violence Intervention Program. That is not you show up one time for like a half hour and watch a video on don't hit your girlfriend. It's a series of classes. So it's a pain, but it's meant to be a pain because it's meant to help you come up with a way other than burning a bill of sale when you get frustrated with someone important in your life. And I'm guessing with the volume of kids you've got, you're going to have some complicated situations with the moms and with the kids. And the more you can figure out a way to work through those without getting angry and hitting someone or breaking something, the better off you're going to be because you're on probation for a bunch of years in these 2 counties. Special condition number 2 is the 100 hours of community service. You're going to need to take care of that in the first 9 months of your probation. And then finally, no violent contact with Ms. Alexander. It's a pretty easy condition. You can call her, you can be in the same space with her. What's the name of the kid you've got with her?
Legend.
Legend?
Legend.
All right. My bailiff's kid's name is Legend. He's not here today, but you're going to want to see Legend, and that's going to mean you and Ms. Alexander can be in the same place. Just keep it low key with her. Okay. Is her husband big?
Oh, I ain't meet him. I don't know.
Okay. All right. Well, just factor that in. All right. Last thing, Ms. Wood from me. Can someone from my office sign the indictment on your behalf?
Yes, Judge.
Ms. Willingham?
Yes, Judge.
And Mr. Walker, can we sign your name indicating your plea to the 3 counts and the dismissal of the other counts?
Sir, I got one more question.
Yeah.
So since you said I did 53 days, right? How much longer I got?
Oh, do you have any other holds you're aware of? Like, does some other county want you? You should get out this weekend.
Okay.
Yeah, so I'm gonna sign your sentence today. That immediately gets transmitted over to the jail. They're gonna look at that where it says serve 1 month. They're gonna say he did 53 days. So they're gonna process you out. I can't promise you get processed out today, but if you wake up on Monday morning in a jail cell, call Ms. Wood because something got stuck and you need to get out. Okay. Officer Evans, good morning. Can you please talk with Mr. Walker about connecting with probation?
Yes, Your Honor. Mr. Walker, what is your current address?
2444 Santa Rosa Lane.
2444 Santa Rosa Lane
Yes, ma'am.
or Drive?
I think it's Lane.
Okay.
Could
Is
be
there an
Drive.
apartment number?
No, it's a house.
Okay, because it appears that there was a visit, but someone there stated that you didn't reside there. Is that the correct address? 244
Yeah, that's
Santa
address.
Rosa. I'm sorry?
That's the address.
Okay.
Is that a house or an apartment?
The house.
It's a house, okay. And who lives at that house?
It's a number of people.
Okay, who lives there who would know you?
Eddie Copeland.
Eddie Copeland?
Yeah,
I thought you said it's your godmother's house.
No, I was naming all the people say that the Copelands. Eddie.
The Copelands.
Yeah.
Is your godmother a Copeland?
Yeah.
Okay.
That's Ebony Copeland.
Ebony Copeland. All right, so Ebony Copeland should know Mr. Walker. All right.
And do you have Miss Copeland's number?
No, I was speaking to my sister.
How about you? Why don't you
what's
give
your
her your
contact
sister's
number?
name and number?
It's in the jail.
Oh, you don't know your sister's number?
This number.
This my girl.
Do you want me to put that in there for you?
Yeah.
I have a number you can reach him at.
Okay.
470-860-2563.
And whose
may I
number is
have
that?
who that is?
Brianna Smith.
Any kids with Miss Smith? No,
That's it.
not yet. 6 isn't enough. All right. Do you need, I guess you need to give Mr. Walker reporting instructions.
Yes, Your Honor. Mr. Walker, are you familiar with the Atlanta Probation Office at 276 Memorial Drive?
I'll make myself familiar though.
Okay, you're going to report to 276 Memorial Drive. That's Southwest Atlanta, 30303 on July 9th, 2024 at 10 a.m. Failure to do so may result in a warrant for your arrest. Do you understand?
Yes, ma'am.
I'll be
Good luck to
clear.
you, Mr. Walker.
It will result in a warrant for your arrest. And that's a little ways down the road, July 9th. So just make sure you don't forget about it. Ms. Wood's writing it down, but don't let that slip your mind.
And Your Honor, I'll also provide those set instructions through the jail.
Okay, great.
Thank you.
Right here for you, and that's the address.
Thinking we can just.
And
That's it. Thank you, Ms. Willingham.
Okay.
You may. Mr. Shapiro's back, so I'll let you go.
Well, let me see you in a jumpsuit again.
It's
Okay?
Oh, okay.
Have a good one.
I need a few more. I mean, we can
If it's green.
Thank you, Jasmine.
They'll stipulate to the technicals.
Ms. Wood, you were unfortunately tied up with this. Where are we with Mr. Marquez's possible plea? Was that something Mr. Shapiro had to be looking up? But you informed, had you been talking with Mr. Jordan about the case?
Yes.
Okay. Are we able to move forward with Mr. Marquez?
Fortunately, no, Judge. I think we are going to be able to resolve that case. The state needs to follow up on some information regarding the extent of the victim's injuries. However, I think there is a possibility that this may be appropriate to refer to our adult diversion program.
Oh,
Or if not, we'll reach out to Ms. Wood about another resolution.
and does adult diversion accommodate folks for whom English is not their primary language?
It's actually an excellent question, Judge, so let me follow up on it.
Okay, well, we'll work through that. If we could get our interpreter back and we can talk to Mr. Marquez real briefly. What is the plan about, he is driving around with a warrant
Yes.
out for him?
And the state's not going to object to lifting the warrant, Judge. I think Ms. Wood explained sort of what the mix up there.
Yes.
Okay, Mr. Marquez, can you hear us?
Señor Márquez, ¿nos puede oír?
Sí.
Yes.
Mr. Marquez, we're not going to be able to resolve your case today.
Señor Márquez, no vamos a poder resolver el caso de usted el día de hoy,
But we hope to soon.
pero esperamos que pronto lo podamos hacer.
I need to get your address.
Necesito su dirección.
Can you tell me what it is?
¿Me puede decir cuál es?
Right now, ahora mismo estoy en Iowa.
Right at the moment, I'm in Iowa.
Okay. Do you have an address in Georgia?
¿Tiene usted una dirección en Georgia?
Sí,
Yes, I do.
What is that?
¿Cuál es?
es 1413 Lucky Street en Griffin, Georgia.
It's 1413 Lucky Street in Greenville, Georgia.
Griffin.
Griffin, Georgia.
Does he know the zip code?
¿Sabe usted cuál es el código postal?
Es 3012. En este momento no me acuerdo muy bien, pero es 30012.
It is 312, I can't remember well, I think it's 30012.
Judge, can I interject?
Please.
There is a change of address in Odyssey for the Griffin location in November of 2021. So this is kind of a complicated situation. I'm in contact with an English-speaking family member. She's texted me the Iowa address as well. He's back and forth between Georgia and Iowa for work purposes. That is part of the reason I believe he missed court originally.
Well, and I'm looking now at that change of address. It didn't stick because the system has a Fairburn address for Mr. Marquez. So we'll get the Lucky Street address 30223 into the system. And I guess you've got a good connection through the English-speaking relative.
Yes, Judge, and if I just may give you a little bit of context so that this is makes more sense. The family member contacted me, I think in January of this year, letting me know, hey, he was trying to keep up with this case since 2021. Then he got this job that keeps him between Georgia and Iowa. What can we do? Mr. Jordan and I talked about it in January. That's why I filed a waiver in January, trying to get it moving.
Yeah.
And then I dropped the ball and we never got it on a calendar. So
Okay.
that's where we are. And she contacted me a few weeks ago and said, hey, what's the update?
Okay. Do you have a way to contact Mr. Marquez directly, or you go through the relative?
So I have his direct number and I have hers. And so it's just been easier to have her as our interpreter.
Yes. And what is her last name?
That's a good question.
Or first, whatever he'd know her by, because I just want to let him go, but I want to explain what's going to happen next.
Your Honor, do you want all of this interpret?
No, I'm going to give you one last thing to share with him.
All right,
Thank you. I wasn't ignoring you. I was saving you a moment.
I understand. I've been keeping notes just in case.
Judge, my internet also went out, but Ms. Rios is working. So just looking at my email real quick.
Is that, should I call IT, like the internet's dropping? Mine's wired, so it's good, but Ms. Nix, have you been good with the internet?
I have.
Okay,
This is just me and Ms. Willingham.
okay. If you could let Mr. Marquez know that Ms. Wood will be contacting him soon.
Señor Márquez, la señorita Wood se va a comunicar con usted a la brevedad posible.
And also if you'll let him know that I will be speaking with Yolanda as well.
Y you're Miss Woods,
Yes.
right? Okay, I just want to make sure. La licenciada Woods me acaba de decir que ella va a estar en comunicación with Yolanda Hernández.
Tengo
¿Perdón?
tengo el zip code de Griffin.
30223.
Es 30223, dice el juez.
30212 y 30213. Correcto, gracias.
Well, it's 30212 and 30213.
Okay.
Thank you.
All right. And you can also let Mr. Marquez know that I'll be setting aside the bench warrant.
Y señor Márquez, para que sepa, el juez va a retirar la orden de arresto que había en contra de usted.
Gracias.
Thank you.
I don't want to lose track of the case, so what should we do? Set it for inquiry in a month, or what's a reasonable next step?
I think a 30-day inquiry calendar, Judge, would work.
Okay. All right, and then Mr. Jordan will be back in the loop on that one. All right. All right, so if you could let Mr. Marquez know, we'll be meeting again in about 30 days.
Señor Márquez, vamos a reunirnos de nuevo como en 30 días.
Está bien.
That's fine.
Does he have any questions?
¿Tiene usted alguna pregunta?
No,
No.
When will he next be back in Georgia?
¿Cuándo es la próxima vez que va a estar de vuelta en Georgia?
el trabajo me termina en 2 meses, pero si necesito ir, está bien.
Well, my job ends in 2 months here, but if I need to go there, it will be all right.
Okay, what does he do in Iowa?
¿Y qué es lo que hace en Iowa?
Estoy trabajando en una compañía de trailers.
I'm working in a trailer company.
Okay. Do you have anything else, Mr. Shapiro? I know this is only your case temporarily.
No, Judge, I don't think there's anything additional from the state. We should be able, I think, to
Sort this out.
sort this out.
Okay. Thank you, Mr. Marquez.
Gracias, señor Márquez.
Muchísimas gracias a ustedes.
Thank you so much.
Okay, he's free to go.
Ya se puede retirar.
Gracias.
Thank you.
And you are too. Thank you for covering.
Thank you, Your Honor.
And thanks, Ms. Wood, for getting this in here, and in 30-ish days, we'll see everyone again.
Thank you, Judge, I appreciate that.
May I have your signature, Your Honor?
Yes, ma'am.
Do you have a plea ready?
Yeah.
Okay, great. Wanna go do our plea? Wanna do our plea?
Thanks so much. Bye-bye.
Oh, I even noticed.
So we can go in whatever order you want. Ms. Cabrera and Mr. Walton are ready. We also could maybe do, I don't know if you want to do 2 at once.
I was going to suggest, Judge, I think we may even be able to do all 3 at once, since there are similar conditions.
Oh, and Mr. Luemba is here. Do we have, but we were missing one. I'd love to do all 3. Is Ms. Jackson on? Hey, Mr. Luemba, how are you?
Hey, how you doing, Judge? Can you hear me?
Yes, sir. Can hear you and see
You
you.
should be on, Ms. Jackson, if you would turn on your
Yes, I'm here.
camera. And
She's here. Okay.
okay, great.
So, Mr. Francis, do you have any concern about doing all 3 pleas together? Ms. Cabrera, are you okay with that? She's nodding her head, yes. Okay. And Mr. Luemba, are you okay? I think the recommendation in all 3 cases is the same. They're a related set of allegations. And so the thinking is we do all 3 pleas at the same time. Are you all right with that, Mr. Luemba?
I'm fine with that, Judge.
Okay, let me fill up the screen here. We've got lawyer 1 and client 1. Hey, Mr. Walton, I need you to turn your camera on, please. While he's doing that, I'll add Mr. Luemba, and then is that Ms. Jackson? Yep, okay. And then we need Mr. Walton, and he is right there. Excellent. And then is Mr. Burnett still online or in?
Yes, sir.
Or at your Zoom user, add spotlight. Okay. Whoop, nope. Where's Mr. Burnett?
I'm here.
Oh, he's there. Okay.
Yes, sir.
Yep. Who's on with the? Yeah. Orange shirt.
That was me. I'll take it off. I got hot.
Okay, I was like, there's a guy with an orange shirt, and I don't see the orange shirt.
You didn't want to clash with Mr. Cabrera.
Got it. Okay. I was hoping it was a San Francisco Giants shirt. I was going to give him a month off.
Yeah, a little really made.
Yeah. then we'll add that. All right, I think we've got everyone we need except Mr. Francis.
I'm right here.
Yeah, no, I'm just, thanks. If you can slide over one seat, just so you're there, or you can, yeah, either way, I just need your client to be able to see you and you're on that camera. Woo, what a busy screen.
And Judge, if I could ask Officer Evans.
Did you get my text, Mr. Burnett?
Yes, sir, I did.
Okay, all right.
I'm unfortunately without criminal histories for all three co-defendants, so if Officer Evans can be looking into that while we're taking the plea.
It's actually Ms. Jackson. We've got Ms. Jackson from pretrial, and she'll have it already. And so I will ask her at the appropriate time. You bet. All right, let's get on the record, please. We are dealing with case 24 SC 000053. We have Ms. Jackson, who is represented by Mr. Luemba. Ms. Jackson is on the screen as iPhone with the green nails. We've got Mr. Walton. Whoop. Someone, we need to mute. It's here. Got it. All right. We've got Mr. Walton, who is represented by Ms. Cabrera, and Mr. Walton is on by his name, so we can see him. And then we have, where's my other calendar page? Mr. Burnett, who is on as Zoom user, and he is represented by Mr. Francis, who is at defense counsel table here in the courtroom. And we're going to move forward with a plea for all three. Mr. Burnett, Mr. Walton, and Ms. Jackson. The way this will work is that all three of you are going to be sworn in just a moment by Mr. Shapiro. He's the guy who are on the screen. It says WTNS. He's the prosecutor. Once you are under oath, you're going to need to answer his questions truthfully and completely. A lot of them are just going to be yes or no questions. He's going to ask the question just once, and then he will say, Ms. Walton, Mr. Walton, or Ms. Jackson. He'll call you by name, and please answer when he calls your name. That way the record will reflect Ms. Jackson's answer, Mr. Walton's answer, and Mr. Burnett's. If any of the three of you has a question at any time, wave your hands or say, excuse me, because we need to make sure you understand what's going on. If any of the three of you needs to speak privately with your lawyer, we can make that happen as well. We'll just put you in a breakout room, Mr. Burnett and Mr. Francis have already had a breakout room discussion, and we can do that for the others if you need it. But I think your cases are all working out in about the same way. Ms. Jackson, are you ready to go forward?
Yes.
Mr. Walton, are you ready to go forward? Yeah, I need you to say yes on the record out loud.
Did you say Miss Jackson?
Yes.
No, she already answered. Mr. Walton, you ready to go forward?
Yes.
And Mr. Burnett, you ready?
Yes, sir.
Great. Mr. Shapiro, take it from here, please.
All right, thank you, Judge. Mr. Walton, let me begin with you, sir. If you would please raise your right hand. Do you swear or affirm that any statements or testimony that you will give in this matter now before the court will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. Could you please state your true and correct legal name for the record?
Judge,
Hold on one second. Yes, Ms. Rivers?
Mr. Shapiro, put the microphone in front of you, please.
Oh, I'm sorry, Ms. Rivers.
Thank you.
Is that better?
Yes, thank you.
Okay. Mr. Walton, could you please state your true and correct legal name for the record?
Trayvon Walton.
All right, thank you, Mr. Walton. Ms. Jackson, would you please raise your hand? Do you swear or affirm that any statements or testimony that you will give in the matter now before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. You can lower your hand. And Ms. Jackson, if you would also just state your true and correct legal name for the record.
May Jackson.
All right, thank you, Ms. Jackson. And finally, Mr. Burnett, would you please raise your right hand?
Sir.
Do you swear or affirm that any statements or testimony that you will give in this matter now before the court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, thank you. You can lower your hand. And Mr. Burnett, would you please state your true and correct legal name for the record?
Brian Burnett.
All right, thank you very much. Mr. Walton, returning to you, are you at this time taking or under the influence of any medications, drugs, or alcohol?
He just disappeared.
Dropped off.
So why don't you ask the others, and hopefully Mr. Walton will rejoin us.
Absolutely. Ms. Jackson, are you at this time taking or under the influence of any medications, drugs, or alcohol?
No,
Is there any medication that you normally take that you have not taken today?
no,
How old are you, Ms. Jackson?
24,
And how far did you go in school?
11th grade.
Are you able to read, write, and understand the English language, ma'am?
Yes,
Okay, thank you very much. And Mr. Burnett, are you at this time taking or under the influence of any medications, drugs, or alcohol?
No, sir.
Is there any medication that you normally take that you have not taken today?
No, sir.
How old are you, Mr. Burnett?
38,
And how far did you go in school?
12.
Are you able to read, write, and understand the English language?
Yes, sir.
All right, thank you. And returning to Mr. Walton, are you at this time taking or under the influence of any medications, drugs, or alcohol?
No,
Is there any medication that you normally take that you have not taken today?
no.
How old are you, Mr. Walton?
24.
And how far did you go in school?
I completed high school.
All right. Are you able to read, write, and understand the English language?
Yes.
All right. Thank you, Mr. Walton. Mr. Walton, do you understand that you were charged in this indictment with a single count of cruelty to children in the first degree?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to that charge?
Yes.
Do you understand that if you were to plead not guilty or were to remain silent and refuse to enter any plea at all, then the state would be required to prove this charge against you at a jury trial?
Yes.
All right. Thank you, Mr. Walton. Ms. Jackson, do you understand that you were charged in this indictment with a single count of cruelty to children in the first degree?
yes,
Do you understand that you have the right to plead either guilty or not guilty to that charge?
yes,
And do you understand that if you were to remain silent and refuse to enter a plea or were to plead not guilty, then the state would be required to prove that charge against you at a jury trial?
yes,
And then finally, Mr. Burnett, do you understand that you were charged in this indictment with a single count of cruelty to children in the first degree?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to that charge?
Yes.
And do you understand that if you were to plead not guilty or were to remain silent and refuse to enter any plea at all, then the state would be required to prove that charge against you at a jury trial?
Yes, sir.
All right, Mr. Walton, have you had enough time to speak with your attorney about all of the charges in the indictment against you, including all of the facts and circumstances related to the charge?
Yes.
Do you need any more time to discuss the case with your attorney?
No.
And are you
You sure?
satisfied?
They can do a breakout. They can do a breakout room if you're not sure.
Oh, could I ask you a question privately?
You bet. I'm going to put the two of you in a breakout room. When you're done, just pop back into the call.
Absolutely.
And we'll move forward with the other two and then catch up with Mr. Walton when he comes back. Give me,
Thank you, Judge.
you bet, a second. All right, they're in a breakout room. Let's press forward with Ms. Jackson and Mr. Burnett.
Ms. Jackson, have you had enough time to speak with your attorney about all of the charges in the indictment, including the facts and circumstances related to those charges?
yes,
Do you need any more time to discuss the case with your attorney?
no,
Okay. And are you satisfied with your attorney's services?
yeah,
And Ms. Jackson, you understand that if you do need some more time to speak to your attorney, we can put you two in a breakout room together?
mm-hmm,
Do you need any more time to discuss the case with your attorney?
no,
All right, thank you. Mr. Luemba, are we waiving a formal reading of the indictment for purposes of the plea?
Yes, for purposes of the plea, we are.
And are we waiving any and all defects in the indictment for purposes of the plea?
Yes.
All right, thank you very much, Ms. Jackson. Mr. Burnett, have you had enough time to speak with your attorney about all of the charges in the indictment against you, including the facts and circumstances related to those charges?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
And are you satisfied with your attorney's services?
Yes, I am.
All right, and Mr. Francis, are we waiving a formal reading of the indictment for purposes of the plea?
Yes.
And are we waiving any and all defects in the indictment for purposes of the plea?
Yes.
All right, thank you, Mr. Francis. And Judge, if you want me to move on with the two that we still do have, or wait for Mr. Walton to come back, I don't know what would be easier.
Let's move on with these two. I'd love to get them going where they need to go.
Understood, Judge. So, Ms. Jackson, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
I'm sorry, can you repeat that?
Sure. Has your attorney advised you of the potential minimum and maximum penalty for the charge to which you're entering a guilty plea today?
Yes.
So do you understand that the charge of simple battery carries a potential sentence between 1 and 12 months in custody?
Yes.
And Mr. Burnett, has your attorney advised you of the minimum and maximum sentence for the charge of simple battery?
Yes, sir.
And do you understand that that carries a potential 12 months in custody?
Yes, sir.
Now, Ms. Jackson, is it your understanding that today you're entering what's called a negotiated plea of guilty?
Yes.
And is it your understanding that in exchange for your guilty plea, the state is going to recommend to the court that you be sentenced to serve 12 months probation, and that as a condition of your probation, that you have no further contact with the victim in this case?
Yes.
Okay. Now, Mr. Burnett, is it your understanding that today you're entering what's called a negotiated plea of guilty?
Sir.
Is it your understanding that the state is going to recommend 12 months probation, and that as a condition of your probation, that you have no further violent contact with the victim in this case?
Yes, sir.
And so, Judge, I just wanted to highlight, that was the one thing that ADA Jordan was able to clarify, is Mr. Burnett's condition is different from the remaining co-defendants in that it's no further violent contact.
Right, it's his daughter.
Correct, Judge.
Understood.
All right, Ms. Jackson, do you understand that the court is not required to accept the state's recommendation?
Yes.
You understand that the court does have the right to sentence you to the maximum possible sentence for this charge, which in this case would be 12 months in custody?
Yes.
And Mr. Burnett, do you understand that the court is not required to accept the state's recommended sentence?
Yes, sir.
Do you understand that the court has the right to sentence you to the maximum possible sentence for this charge, which in this case would be 12 months in custody?
Yes, sir.
Ms. Jackson, do you understand that if the court decides to order a sentence that differs from the negotiated plea you were anticipating today, you do have the right to withdraw your plea of guilty?
Yes.
And Mr. Burnett, do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting, you would also have the right to withdraw your guilty plea?
Yes, sir.
Ms. Jackson, are you currently on probation or parole?
No.
Do you understand that while on probation, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes.
Do you understand that while on probation, you must follow the special conditions of your probation, including those that I've just described for the court?
Yes.
And do you understand that if you were to violate those conditions by trying to have contact with the victim, then the court could revoke your probation and you could be subject to serve out the balance of your sentence?
Yes.
Do you also understand that you are not allowed to possess or use a firearm while on probation?
Yes.
All right, thank you, Ms. Jackson. Mr. Burnett, are you currently on probation or parole?
No, sir.
Do you understand that while on probation, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes, sir.
And do you understand that while on probation, you must follow all the special conditions of your probation, in this case, that you have no further violent contact with the victim?
Yes, sir.
Do you understand that if you were to violate that condition, then you could be subject to a revocation of that probation for the balance of your sentence?
Yes, sir.
And do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
All right, thank you, Mr. Burnett. Judge, I see Mr. Walton is back on.
He is back, so if you want to catch him up, that would be
Judge.
great. Thank you for keeping track.
All right, Mr. Walton, did you have the opportunity to discuss any questions you had with your attorney while you were in the breakout room?
Yes.
And do you want to move forward with your guilty plea this morning?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
And are you satisfied with your attorney's services?
Yes.
Ms. Cabrera, are we waiving a formal reading of the indictment for purposes of the plea?
Yes, so waived.
And are we waiving any and all defects in the indictment for purposes of the plea?
Also waived.
Now, Mr. Walton, has your attorney advised you of the potential maximum sentence for the charge to which you're entering a guilty plea today?
Yes.
Do you understand that the charge of simple battery carries between 1 and 12 months in custody?
Yes.
And do you understand that today you're entering what's called a negotiated plea of guilty?
Yes.
Is it your understanding that in exchange for your guilty plea, the state's going to recommend to the court that you serve 12 months on probation and that as a condition of your probation, you have no further contact with the victim?
Yes, sir.
Do you understand that the court's not required to accept that recommendation?
Yes.
I'm sorry, what was that, Mr. Walton?
Yes. Yes.
Okay. Do you understand that the court does have the right to sentence you to the maximum possible sentence, which in this case would be 12 months in custody?
Yes, sir.
Do you understand that if the court were to enter a sentence that differs from the negotiated plea you were expecting today, you do have the right to withdraw your guilty plea?
Yes.
Mr. Walton, are you currently on probation or parole?
Yes, sir.
Okay. Do you understand that you're entering a guilty plea today could result in your probation or parole being revoked?
Yes, sir.
All right.
Well,
And do you
I'm sorry, I ain't mean to interrupt, but my probation is currently where I'm at now. It's not in Georgia.
Say that again. You're on probation now?
Yeah, but it's not in Georgia.
He's
Where is it?
It's in Oregon.
Okay. And when did you get put on probation?
Last year.
Okay. Well, you're good to go in this sense. The conduct that you're pleading guilty to today is from many, many years ago. And so it cannot serve as a basis to mess with your probation in Oregon. You're going to want to let your probation officer in Oregon know, hey, by the way, I'm on misdemeanor probation out of Georgia. They'll want to know what the situation was, and you'll explain there was an incident in 2019 or 2020, and that's not a basis to revoke your much more recent probation in Oregon. So you're just going to be a popular guy and be on probation in 2 different states. Okay?
Okay.
All right.
All right. Mr. Walton, do you understand that while on probation, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes.
And do you understand that you must follow the special condition of your probation that you have no further contact with the victim in this case?
Yes.
Do you understand that if you were to violate that condition, then you could be subject to a revocation of your probation for the balance of your sentence?
Yes, sir.
And do you understand that you're not allowed to possess or use a firearm while on probation?
He froze.
Did you answer that? Oh, he froze.
He
Come on.
froze.
There, he's back. All right. You understand?
I froze. My bad.
That's all right. We'll blame your phone, not you. You may not have a gun while you're on probation. You understand that?
Yes, sir.
Okay.
All right, Mr. Walton, do you understand that by entering a guilty plea, you are waiving any and all defenses, including any mental health defenses?
Yes, sir.
And do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if you were convicted of these charges at a trial?
Yes, sir.
Is it your decision to waive those rights, which means not to use them, and to enter a guilty plea today?
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No, sir.
And is it your decision to enter a guilty plea because you are in fact guilty?
Yes, sir.
Mr. Walton, how do you plead to the reduced charge of simple battery?
Guilty.
All right, thank you, Mr. Walton. Ms. Jackson, do you understand that by entering a guilty plea today, you're waiving any and all defenses, including any mental health defenses?
Yes.
And do you also understand that by pleading guilty, you are giving up the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if you were convicted of these charges at a trial?
Yes.
Is it your decision to waive those rights, which means not to use them, and to enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No.
And is it your decision to enter a guilty plea because you're in fact guilty?
She's going to be pleading guilty under Alfred v. North Carolina.
All right. Thank you, Mr. Luemba. Ms. Jackson, Is it your intention to plead guilty because you've decided that it's in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, that this is a plea of guilty and would place you in the same position as if you were convicted by a jury at a trial?
Yes.
Ms. Jackson, understanding that this plea is being entered pursuant to Offord versus North Carolina, how do you plead to the charge of simple battery?
Guilty.
All right, and Mr. Burnett, do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that you're also giving up the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, and the right to the presumption of innocence, and the right to appeal if you were convicted of these charges at a trial?
Yes.
Is it your decision to waive those rights, which means not to use them, and to enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No.
And is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Mr. Burnett, how do you plead to the offense of simple battery?
Guilty.
All right. Mr. Walton, is your guilty plea entered freely and voluntarily with full knowledge of the charge against you?
Yes, sir.
Ms. Jackson, is your guilty plea being entered freely and voluntarily with full knowledge of the charge against you?
Yes.
And Mr. Burnett, is your guilty plea being entered freely and voluntarily with full knowledge of the charge against you?
Yes, sir.
All right, I need to make everyone aware of some appellate rights. First being that you will have a limited right to appeal this guilty plea conviction, beginning with you would have only 30 days from today to file a direct appeal of this conviction. Mr. Walton, do you understand that?
Yes, sir.
Ms. Jackson, do you understand that?
Yes.
And Mr. Burnett, do you understand that?
Yes, sir.
Do you also understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea? Mr. Walton, you understand that?
Yes, sir.
Ms. Jackson, you understand that?
Yes.
And Mr. Burnett, you understand that?
Yes, I do.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition? And because this is a misdemeanor offense, you would have only 12 months from today to file a habeas corpus petition. Mr. Walton, do you understand that?
Yes.
Ms. Jackson, do you understand that?
Yes.
And Mr. Burnett, do you understand that?
Yes, sir.
And that until they withdraw, your attorneys will represent you until the end of the current term of court or 30 days from today's date, whichever is later. Mr. Walton, do you understand that?
Yes.
Ms. Jackson, do you understand that?
Yes.
And Mr. Burnett, do you understand that?
Yes, I do.
All right, thank you very much. Your Honor, regarding the factual basis for these pleas, I know the court's familiar with this case from the other co-defendants, but this is essentially an investigation that arose in 2021. That was a multi-jurisdictional investigation by the Division of Family and Children's Services. There had been an initial report made about concerns of inadequate supervision of 3 victim children, all of whom resided at the location where Mr. Walton, Ms. Jackson, and Mr. Burnett were also residing. As a result of the report to DFACS, the case was investigated by law enforcement. The initial investigation, as part of the initial investigation, officers responded to Hutchins Elementary along with DFACS workers. They interviewed the victim children, and with respect to these 3 co-defendants, the victim children are Anaya Hill and Antonio Hill. Anaya was 9 years old.
I think it's Anaya Burnett.
I'm sorry, Judge. Anaya Burnett and Antonio Hill. Anaya was 9 years of age and Antonio was 10 at the time. During that initial investigation, the children made disclosures about possible physical abuse taking place in the home. And so as a result, officers referred them for forensic interviews and also to be treated by medical personnel. With respect to Mr. Walton and Ms. Jackson, on February 2nd of 2022, Antonio Hill underwent a forensic interview in which he described that he had been physically abused by multiple persons that were in the home. Specifically, Miss Jackson is an aunt to Antonio. Mr. Hill, who was also a previous co-defendant in this case, was his uncle. But Antonio described multiple instances of physical abuse from the adults that were in the home. Specific to Mr. Walton and Miss Jackson, Antonio described that Miss Jackson would strike him in the face, punch him in his chest, whip him with a belt. He described that the beatings took place sometimes for no reason, sometimes as punishment for misbehavior. He described that these beatings would leave markings on his leg, as well as scratches and red lines. For Mr. Walton, who is, I believe, cousin to Antonio Hill, Antonio described that his cousin would hit him on his knees and legs, leaving marks. He also described receiving bruises from Mr. Walton, and also described that Mr. Walton would also abuse the other children in the home, including Caden and Anaya. Finally, for Mr. Burnett, as part of the investigation, Anaya, who is the stepdaughter of Mr. Burnett, was admitted to Hugh Spalding Hospital, where doctors noted that there were multiple contusions, bruising on her left arm, right arm, upper thigh, that there was a small healing laceration under her left eye, all of which indicated some kind of non-accidental trauma. When doctors assessed and spoke to Anaya, again, they noted bruising in various stages of healings. She reported that she was getting whoopings from her grandmother and from Mr. Burnett, who at the time was, as I understand it, in a relationship with Anaya's mother. She reported that she had repeatedly told school officials that she had fallen out of a tree, but the doctors immediately noted that the signs that were present on Anaya were concerning for physical abuse. And so Judge ADA Jordan noted that the resolution for all of these co-defendants has been discussed with the parents of the victim, and they are in support. It was ADA Jordan's belief that this was a case that was more driven out of poverty and perhaps just a misunderstanding of appropriate discipline. And so would just ask that the court accept the state's recommendation.
All right. Let me work my way around. Let's start with Mr. Luemba. Well, let me do this first. Ms. Jackson, if you could share with me I'm sorry, I need to be clear which Jackson I'm talking about. I'm referring to Bridget Jackson with Pretrial Services. Could you share with me, please, any criminal history information you have for these three defendants?
Okay. With Miss Jackson, there are no prior arrests on file, Your Honor.
All right.
Mr. Walton, he has 6 cycles. The last arrest was April the 7th, 2023, for 2 counts of carrying a concealed weapon, a misdemeanor, and fleeing or attempting to elude an officer. That appears to be a felony. And I think that was out of Oregon. He does have 1 misdemeanor conviction that was in 2018 out of Texas for evading an arrest. And for Mr. Burnett, he has 20 cycles. The last arrest was April the 5th, 2021, out of Muskogee County, Georgia, for a DUI. There was no disposition for that arrest. He does have prior felony convictions.
Excuse me, that's my dad.
Okay, all right.
Do you have the same? Is he also a Brian?
Yes, sir.
Okay. What, Ms. Jackson, do you need from Miss Burnett to distinguish the two? Do you need a social or a date of birth?
I can get the date of birth and I can go back and take a look at Mr. Burnett, please.
Okay. Mr. Burnett, what's your date of birth?
05/17/1986.
1986?
Yes, ma'am.
Okay, Your Honor, if we could hold on Mr. Burnett, please.
Yep, definitely. We'll circle back and get the revised version. Mr. Burnett, thank you for flagging that. 20 cycles. With that was a bit. Okay. Let me start then with Ms. Jackson, as in Mr. Luemba's client. And Mr. Luemba, anything you want to add on behalf of your client?
Yes, Judge. Can you hear me?
Yes, sir.
Yes, Judge. My client is 24 years old. She's the mother of a 6-year-old. As you heard her say, Judge, she went to 11th grade, and we're taking this plea under Alford because obviously the predictable outcome is better than an unpredictable outcome. We feel like it's better than taking our chances at going to trial. But Judge, Miss Jackson is currently out of work. She is a stay-at-home mom taking care of her child. So we are asking that on this 12-month probation that her probation fees be waived because she is not able to pay those probation fees. In addition, Judge, even though she will be actively looking for work, she does not want this this criminal conviction to hinder her from finding employment. So, and we talked about it in depth. And after weighing the pros and cons, she wants to take this plea under first offender. And we're also asking that her record be sealed once the plea is taken so it doesn't hinder her employment opportunities in the future. But outside of that, Judge, we just ask that you accept the negotiated plea as tendered by the state.
Got it. Okay. Ms. Jackson, anything you want to add?
No.
Okay. What's the last job you had? It sounds like right now your job is taking care of your child. When's the last time you worked outside of the home?
I think it was at a Macy's warehouse.
How long ago was that?
Like maybe 6 months ago.
Say that again?
Maybe 6 months ago.
Okay. All right. And your child is 6?
Yes.
Okay. Boy or girl?
Boy.
Okay. So he's in, what does that mean? He just did kindergarten or he'll start kindergarten in the fall?
He was just in kindergarten.
Okay. So he'll start first grade in the fall?
Right.
Where will he go to school?
I'm not sure yet.
Why are you not sure?
Because I was trying to see if I wanted to transition him to his biological family, but I'm not sure. So I still have to think about it.
Got it. Stuff to work through this summer. Okay.
Right.
Thank you. Do you have any questions, Ms. Jackson, about any of the things we've discussed?
No.
First offender is an opportunity that you qualify for. You've never been arrested before, other than in this case. You have no convictions. If I sentence you as a first offender while you will be on probation, it will not be a conviction. So if you are looking for work or you want to go back to school, you don't have to check any of those boxes that say I'm a convicted anything, felon or misdemeanor. That's the benefit, and it will be pretty easy to get this expunged from your record after you finish your probation. The one risk is that if while you're on probation, something doesn't go well, you get arrested for something else, I can revoke your first offender status and resentence you up to the maximum in this case. Do you understand the benefit of first offender and the risk?
Yes.
And do you still want to be sentenced as a first offender?
Yeah.
Yes.
All right. Then I will take that into consideration. Let's turn to Mr. Walton and Ms. Cabrera. Ms. Cabrera, anything you want to add on behalf of Mr. Walton?
Yes, Mr. Walton is actually from Georgia, but he lives in Oregon. And it doesn't appear as though he's going to be leaving there. So I'd ask that Your Honor allow him to enter his plea as negotiated. I've expressed to him that he probably have to do an interstate compact to have his probation transferred because he was concerned about having probation in both places. But I'm pretty sure they'll probably transfer that. Other than that, that's it, Your Honor. I don't know if Mr. Walton has anything he wants to address, but I doubt it.
Okay, Mr. Walton, anything you want to add or any questions you have?
No, sir.
All right. Bridget Jackson, have you had enough time to look up the younger Burnett Jr. or 3 or 4?
Junior.
Junior.
Yes, Your Honor. He has 2 cycles. The last arrest was April the 28th, 2007 in Clayton County for a failure to appear. The underlying charge was driving while unlicensed. There were no convictions listed in the GCIC. Nothing in addition.
Got it. Okay, thank you. That's very different. Thank you for clearing that up. Mr. Francis, what do you want to share with me about Mr. Burnett?
Well, Judge, that says it all right there. You know, he has no history.
Right, he's almost 40, no history.
Right, that's pretty good.
Yeah.
He has 2 children, and this plea will allow him to see his children, just no violent contact. He appears to me to be a very conscientious dad, and I hope that he'll steer clear of any issues like this going forward, because he's done well in his life to this point.
Okay. Mr. Burnett, what do you do for a living?
I do construction and I manage a pizza restaurant.
Those are very different. What do you spend more time doing?
Both.
Both. Okay. All right. What's the pizza restaurant?
Papa John's.
All right. Well, good. Anaya is your daughter. Mr. Francis said you have 2 kids. Is Antonio your son, or you are just related?
No, sir. Me and Miss Heflin have another daughter.
Got it. And are you and Miss Heflin still in a relationship, or you are co-parenting?
Co-parenting.
Okay. Got it. So you have 2 kids through Ms. Heflin, one of whom is Anaya.
Yes, sir.
Got it. All right. Do you have any questions about anything we discussed?
With what's going on, would it stop my because I'm supposed to be doing CDLs?
Yeah.
Would this stop my CDL training?
So Mr. Francis will have a better sense. I'm going to give you a tentative, I don't think so. It has nothing to do with driving. If you were pleading to a DUI, you're going to be in a little trouble. It's not a felony. And my experience in working with folks who either are already truckers or are trying to get it, if it's a felony plea or it's a plea that involves any kind of serious driving infraction, that's trouble. That's not what this is. So I don't believe so, Mr. Francis.
I don't think so either.
Yeah, I think you
He
should be.
shouldn't have a problem. I know he's not my client, but having done it before, he should not have a problem.
Okay. So you got 2 experts.
One more thing, I do have license to carry. so I wouldn't be able to have none of my guns then.
Yeah, while you're on probation, no, you may not. Once you're off probation, you can rearm yourself with whatever you'd like to carry around. But I'm telling you, if you get pulled over and there's a gun and you're on probation, that's just going to mess things up. So for 1 year, carry a baseball bat instead. All right.
Yes, sir.
All right. Excellent. I think that then we need to, we covered it. Let me march through these in the order they appear on the calendar. I'll start with you, Ms. Jackson. I find there's a factual basis for your plea, and that your plea is knowing and voluntary. I understand it's an offered plea, but I do find that if this case went to trial and the jury credited the testimony about Antonio Hill and from Mr. Hill, you could be found guilty. Don't know, but I also understand why your lawyer has wisely counseled you take this known thing as opposed to the uncertainty of a trial. And just from my experience, jurors get pretty worked up when they see pictures and hear about little kids being mistreated. That doesn't mean you did anything, just letting you know how that could play out in front of a jury. I will sentence you as a first offender. I'm sentencing you to 10 months of probation. You shall have no contact with Antonio Hill while you are on probation. And for the first 5 months of that probation, I am waiving your probation supervision fees. Any questions about any of that?
So that means after 5 months, I would have to start paying the fees.
It does, which means after 5 months, maybe you'll be working again.
Hopefully. All
right, that's my hope too. Turning to Mr. Walton, way out in Oregon. Mr. Walton, I find there's a factual basis for your plea, in that your plea is knowing and voluntary. And I should be clear, I got to rewind. Ms. Jackson, I'm sentencing you as to count 6 in the indictment, which has been reduced from cruelty to children to simple battery. Mr. Walton, I'm sentencing you to count 7. As I said, I find a factual basis. That's being reduced to simple battery. I'm sentencing you to 10. That's 10 months of probation. You shall have no contact with Antonio Hill. That should be pretty easy because you're in Oregon and he's not. And I will recommend to the misdemeanor probation folks that this be telephonic supervision, as in you dial in and let them know you're doing well. You need to be findable. So I bet you've got a cell phone and they'll need to know what that number is. But I think it's going to be okay that you are in Oregon for purposes of this probation. Mr. Walton, do you have any questions about your sentence?
No, sir.
And finally, Mr. Burnett, you have pled to count 3, which has been reduced to simple battery. I'm sentencing you to 10 months probation. And your special condition of probation is no violent contact with your daughter, Anaya Burnett. So you can be around her. You just need to be around her in a peaceful way. And if she frustrates you because she's a teenager, you just got to walk out of the room and let Ms. Heflin handle it or someone else, but not you. Mr. Burnett, I find there's a factual basis for your plea and that your plea was knowing and voluntary. Do you have any questions about your sentence?
Sir.
Mr. Luemba, may someone from my office sign the indictment on your behalf?
Yes, Judge.
Ms. Jackson, is it okay if we sign on your behalf for your Alford first offender plea?
Yes, but I also have a question.
Yes, ma'am.
Would I have to report to probation?
Where do you live?
In Jonesboro.
Okay, you may have to show up once. It's in Atlanta. It's not going to be the kind of thing where you got to come every week. Misdemeanor probation is typically they're calling in, and as long as you are findable and things are going well, they don't need you to come to their office. But I don't want to promise you that you'd never need to go to the office. It's about a block from the courthouse. So if you've been to the courthouse, you'll be able to find probation. It is literally down the street.
Okay.
All right.
Mm-hmm.
Mr. Walton, is it all right if someone from my office signs your name to the indictment indicating your plea?
Yes, sir.
All right. Ms. Cabrera, can we sign for you?
Yes, Your Honor.
Mr. Francis, can we sign for you?
Yes, Your Honor.
And Mr. Burnett, is it okay if we sign your name to the indictment so you don't have to come down here and sign it?
Yes, sir.
All right. Mr. Shapiro, can we sign for you?
Please, Judge.
All right, we will do that. I think that covers everything. Ms. Nelson, will you be pushing to the lawyers the way in which their clients will be connecting with misdemeanor probation? Yes. All right. So the 3 lawyers will get contact information from Ms. Nelson. If you'll get that to your clients, that's how they plug in with probation. I think that's it. Anything else from the state?
Nothing from the state, Judge.
You did a very agile job jumping into this messy case for Mr. Jordan. He owes you. Mr. Luemba, anything else?
No, Judge.
Thank you for plugging in. I know Ms. Jackson was frustrated at not having counsel for a while, but you've addressed that. I appreciate it. Ms. Cabrera, anything else?
Nothing further, Your Honor.
All right, thank you. As always, you can bill Mr. Luemba for that little extra you did for Mr. Burnett and the CDL. Mr. Francis, anything else?
No, Your Honor.
All right, for the 3 defendants, thank you for your time and for dialing in. Good luck with everything.
Thank you.
Thanks, Judge.
Thank you, Judge.
All right, bye. Mr. Francis, someday we need you and this guy whose name escapes me right now, who's en bond. Is it it's just to work these cases, like a marijuana case and something? We did. Okay. Good. All right. Enjoy it. All right. Escape while you can.
Is that Flint?
Yeah.
Flint. Yes, Flint. That's the guy. All right. That'll be you don't have to bring me something from your trip. You just bring Mr. Flint and that'll be it. Okay, I am open to walking through whatever's next. I know we've got Cameron Miller. Do we have Cameron Miller with 3 cases? That's ready. What about Mr. Franklin? Was Mr. Smith successful or unsuccessful in bending your arm the way he wanted it bent or twisting?
There's, I guess he's gonna send some information to me, potentially mitigating, but
Well, why don't we handle then the final plea colloquy, and that'll get Mr. Franklin and Mr. Smith on his way, and then we can get back to Mr. Miller.
That'll work.
All right. Mr. Franklin, if you could come on up to the podium with your lawyer, please. All right. Let's get on the record. In your case, it's 24 SC 000-867, and you are charged with fleeing and attempting to elude. Mr. Smith is working hard, as he always does, to get you what he thinks is the right outcome. It sounds like he's trying to get something downgraded. Doesn't sound like the state is there yet. Mr. Smith, other than the work you're going to continue to do lobbying on behalf of your client, are you good on the discovery front?
Yes, the state's been very responsive.
Good. That's Ms. Nix's reputation on the discovery front, which is a good one to have. Ms. Nix, what's the state's offer if Mr. Franklin wanted to resolve his case this morning?
Judge, the state's offer is a $5,000 fine in this case because it is the incident date is before the law changed. It does not require the jail time. It is either jail time or the $5,000 fine. And so we are willing to resolve this case for the $5,000 fine.
The old or. Okay. We've actually been working with the clerk's office on how to handle dispositions that are fine only. So no probation even? It's just, or there'd be probation, or it's simply the sentence is pay this fine.
Because of the way that the law is written, you cannot do probation. So it's either you serve all of your time or it's a fine. And now it's you serve all your time and you have a fine. So
okay. Is that your understanding of the situation as the case is currently charged?
Yes.
Okay. So Mr. Franklin, if you were to enter a plea today to the indictment as it charges you, you would be required to pay a $5,000 fine. Understand that?
Yes, sir.
Is that what you're interested in doing, or would you rather say no, thank you at this time and see if Mr. Smith can change the situation for you?
I'm interested.
You're what?
I'm interested in paying fine.
Okay. Do you two need to talk?
You want to take the $5,000 fine?
Yeah, I take it.
Well, we'd enter it as a no-low plea, Judge, but yeah, that's fine.
Okay. Well, why don't you guys talk a little bit more and we will take that plea. Because we thought it was going to be slightly different. I don't want Mr. Smith to be caught too unawares on this. So we can definitely do it, and we'll do it this morning. But I want to make sure you and Mr. Smith have talked about what that'll look like, and we'll do Mr. Miller's, and then we'll turn back to you.
Because it's paid in stanter, Judge, I might need to talk to him just about getting the funds up, and we might need just a brief continuance.
Sure, and just maybe we can get a date that everyone's coming back to do that.
That would make
Because
sense.
that's how it works. The way we worked it with the clerk's office, you go down with your client and they hear that there's a final disposition, but it's not quite signed, and then the money goes and we see the money went through. And so it's a little bit of a 3-step move, but it is in stanter and we can make it happen.
When you say you go down with your clients, it sounds very YSL.
You and Mr. Franklin will go to the clerk's office where the treasury is. I think it's even 2 stops. You may take a copy of the final disposition to one part, and we'll give you operating instructions, and you'll both leave the building unharmed.
Thank you.
Okay? Yep. All right. So you guys talk and we'll figure that out.
Very good.
All right. Ms. Rivers, are you good if we keep going, or do you need a break? That was a lot of takedown for the Burnett et al. Plea.
Yes, Judge, I was about to ask you for just a quick break.
Why don't we take 5 minutes-ish, and when we come back, we will do Mr. Miller's, please.
Okay, thank you.
You bet.
He's not processing 2 of the cases. And
You're not Miss Powell, but Miss Powell is one of the people sitting with you? Okay. Does she need to chat right now, or things are good? Okay, everything else is set up?
No, we're good.
When we're done, you'll set up.
Yeah.
How long do you think that'll take?
Half an hour.
Okay. Yep, we're good. We're just taking a quick break for the court reporter, so I'm gonna be back in a minute. But we just get a new date?
Yeah.
He doesn't have $5,000 on him?
He does have $5,000 on, and then I'll leave in July.
Okay. So we could just add it to a calendar in August. I think that'll work. Let me check one thing. Weird statute.
I did let Mr. Smith know that there's also a probation revocation that has not been handled yet.
And
They haven't filed a petition, it's strange.
It was, I think it was originally filed, and then it was, she just said a revocation was not held. So I would assume that it was,
do you have the case number?
yes, 22 SC 1833334.
But this wouldn't affect that because it sounds like this is super old conduct. Okay. We had first offender in this other case.
This will make him a convicted felon.
It will.
He was on YO information.
He was on what?
Why? First offender.
Oh, okay. So the conduct for which he's on first offender is from March of 21. So this is older than that. It sounds like you were saying it was a 20.
Actually, he pled, so the incident date predates.
Yeah, tomorrow, yes.
This case, but it looks like he didn't plead until 2023, so.
No, but the conduct in this case, the fleeing and attempting to elude, when did that happen?
Oh, January of 2023.
Oh, okay, so it's more recent, but he didn't plead until, okay. So this shouldn't affect the, he's being revoked for some other reason. It wouldn't be this plea.
No, this is this.
Oh, it would be this arrest maybe. Okay. Well, let's try to wrap them together, although,
I thought
there was a revocation, this February in that older case, the other case, because he had failed to report and he had 30 days reduced to time served. So you think there had been another petition out there?
She says there, she emailed.
Okay,
us
I
saying-
thought-
Okay. Okay.
because that's 10 years.
Well, we've got a date. It's August 6th. And maybe you guys can see what we could do with probation as well, as a non-complex case, so I can handle it. I don't need to bug another judge if we want to. I just wouldn't want Mr. Franklin to then have to come back because he paid his fine. We should just wrap it all up into one. So August 6th, there'll be a calendar published. You'll get that. You'll be back from your leave and you'll be here anyway. All right. You bet. So I didn't get to take a break, but Ms. Rivers is back. Should we do Mr. Miller?
Oh, yes, I'm ready.
You ready?
Mr. Miller. Yeah.
Come on up, Mr. Miller. You've been very patient.
Thank you, Your Honor.
We're good. We'll sit tight. Sit tight. No, actually, you need to stay in here. That's what the deputy would want.
Thank you for telling me. I wanted to know. Thank you.
This happens every once in a while. Now, this is how we get new cases.
Sometimes we even have it happen in here. Do you
Yes.
remember that bond hearing, Judge?
Yes, that's right. The biggest, we had a guy after he was found guilty in a bad, not that there's a good one, but a molestation case. And he got up and said, I am not going. He was out on bond. I'm not going, and tried to go that way. And the first time I've had a taser deployed in the courtroom, he got zapped because he was not going. You're here. We can get started. All right. We have Mr. Miller here. This is positions 1 through 3 on our final plea calendar. Are we resolving all 3 cases?
Two of them will be non-process.
Okay, so we're resolving all 3. It's a plea to 1. Which position is the plea?
The one ending in 5. I think it's number 1. Yeah.
Okay, it is. All right, so we're gonna go forward with 22 SC 181325. Mr. Miller is here in court with his lawyer, Ms. Rios. Ms. Nix is also in court. Let me get Ms. Nix on the screen as well, so Ms. Rivers can see everyone. Add spotlight, there you go. Mr. Miller, in a moment, and you've watched this happen now a few times this morning, Ms. Nix is gonna put you under oath. You'll need to answer a bunch of questions. Please do so truthfully and completely. If at any time you've got a question, let me know. It may be something the 2 of you talk about privately. It may be something I can answer, but I won't know you have a question unless you let us know, okay?
Yes, sir.
All right, Ms. Nix.
Thank you, Judge. Mr. Miller, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your true, correct, and legal name.
Cameron Kyle Miller.
You can put your hand down. Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
32.
How far have you gone in school?
Junior year in college.
Is English your native or dominant language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? In 22 SC 181325, identity fraud, driving while suspended license, distracted driving, driving on suspended registration, giving false name to law enforcement, possession of false ID, a failure to have driver's license on person, and failure to wear seatbelt.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am.
Do you need more time to discuss the case with your lawyer, Ms. Rios?
No, ma'am, I do not.
Are you satisfied with her services?
Yes, ma'am.
Ms. Rios, do you waive a formal reading of the indictment for purposes of the plea?
Yes.
And do you waive any and all defects in the indictment for purposes of the plea?
I'm unaware of any defects, but I do waive for the purposes of the plea.
Mr. Miller, do you remember having been arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
You understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court.
Yes, ma'am.
As to count 1, state recommends 4 years of probation, that you complete 80 hours of community service, have no contact with the victim, and that charge will run consecutive to your sentences in counts 2, 5, and 6. As to count 2, state recommends 1 year probation. Condition is no driving. I believe that is the only little part that is not.
And we'll talk about the no driving, but count 2, is that a misdemeanor? So it would be 12 months, or is it a felony?
I guess I should have said
12 months. No, and I know they're the same, but I also want to make sure I know which is misdemeanor and which is felony, because I don't get some of these offenses all that often.
Oh, yes. So the identity fraud is the only felony. Everything else is a misdemeanor.
Got it. That helps. Thank you. So it was how many years probation then on count 1?
Count 1, 4 years probation.
4P. All right.
Consecutive to count 2, 5, and 6, which are all 12 months of probation.
2, 5, and 6. Okay.
So count 2, 12 months probation. Special condition is no driving. Count 3, $100 fine. Count 4, $500 fine. Count 5, 12 months probation, 20 hours of community service. And count 6, 12 months probation. And the 3 misdemeanors, counts 2, 5, and 6 will run concurrently with each other. But count 1 is consecutive to those counts. So it's a total of 5 years probation.
Okay.
And state will not process counts 7 and 8. And if the defendant enters a plea to, in that case, the state will not process 24 SC 000209 and 24 SC 000-209-01. Those are the same case.
Oh, it's a reindictment of,
And-
yeah,
And
okay.
I thought I'd already null pressed the original, but I didn't, so.
Okay. And for, just so I'm clear, for counts 3 and 4, that's fine only.
Yes, sir.
Okay.
All right, Mr. Miller, do you understand that that is the state's recommended sentence?
Yes, ma'am.
You understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that since there are multiple charges to which you're pleading guilty today, that the court also has the right to run those sentences consecutively?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you are expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
To my knowledge, I believe so.
Where?
No.
1 second.
Okay. No, ma'am.
Okay. The question is, are you on probation? Did you take a plea?
Oh, no, ma'am.
Okay. Answer the question.
No, ma'am. I apologize.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you are on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes, ma'am.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of identity fraud, driving while license suspended, distracted driving, driving on suspended registration, giving false name to law enforcement, and possession of a false ID?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that for the felony, you have only 4 years from today to do so, and for the misdemeanors, you have only 12 months from today to do so?
Yes, ma'am.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about March 4th of 2021, the defendant was pulled over for driving while having a phone in his hand. The officer asked for the defendant's driver's license and received a fake driver's license. He ran the license, and the number came back to a female, and then the name on the license, which was Eric Carter, came back to a different number. The officer then asked the defendant for his social security number. He said he didn't know it, but did give a card with the name Eric Carter on it, and that social security number came back to a white male. The defendant was detained and then searched for an ID. Officers found another ID with the defendant's picture and the name Cameron Miller, and the defendant admitted to purchasing the fake ID he presented to the officer. The social security card had been stolen from Mr. Carter. And he was in possession of both the fake ID and the social security card.
So it was a real social security card
Yes.
and fake ID.
Yes.
Okay.
The defendant's driver's license was suspended at that time while he was driving, as was his vehicle registration. Subsequent to that, he was also arrested for fleeing and attempting to elude, and also distracted driving for using his phone while he was driving. He did flee from that traffic stop in this, I guess, total situation. The state agreed to null pros that case in exchange for a plea to the earlier case. But the defendant is showing that he's not good at driving and will, or he's.
He may be a great driver. He is not driving with the appropriate registrations, identifications, et cetera.
Correct, and he's not complying with traffic laws while he is driving. So
maybe not a great driver.
He has a pretty long bad driving history of a lot of driving while suspended, and so that is why we made ask for the condition of no driving just for the first year of his probation.
Okay.
The defendant also he has no felony convictions, but he does have an armed robbery pending in DeKalb County that was supposed to go to trial at the beginning of June. It was reset for the defense attorneys, some health issue. And so I believe that the defense is going to be asking for first offender, but we object based on the continued criminal activity, the fact that he's on bond for a very serious crime, and so we object to that.
Okay, thank you. Ms. Jackson, what can you share with me about Mr. Miller's criminal history?
He has 8 cycles. The last arrest was August the 3rd, 2022 in Dunwoody, Georgia, for misdemeanor obstruction of an officer. He does appear to be on misdemeanor probation in DeKalb County for obstruction of an officer. That disposition date was July the 11th, 2023. And the term is for 12 months. He does have misdemeanor sentences. There's one in 2022. He received a nolo contendere sentence out of Dunwoody, Georgia, for driving while license suspended or revoked. And he received a nolo contendere sentence in 2014 out of Decatur, Georgia, for driving while license suspended or revoked. Nothing in addition, Your Honor.
Thank you. Ms. Rios.
Yes, Your Honor. And I'm sorry about the probation question. He was a little confused. And so I thought he was talking about the pending case, and I thought he was confused about whether that was probation or not, but apparently he's on misdemeanor probation.
For like 3 more weeks.
Yes.
Yeah.
So that's probably what the confusion was. Mr. Miller is 32 years old. He's from Atlanta, lived in Atlanta for the last 10 years. He has 1 daughter, age 14 years old, that he is actively providing for. I'm not sure if it went through, but I did send you pay stubs to confirm that he currently is employed and works for a construction group. They go to stadiums and they install seats and comatics. So he's been doing that for a while, and he would like to continue to be able to do that and go to and from work. And that's why I'm asking. That's why we agreed to everything else except for the driving conditions, because it would make it very hard for him to continue working, going to and from work, and he would need to drive. I do understand about his driving history. He has fixed that. He has gotten his license and reinstated. It is valid. And so these issues will not be reoccurring. And so we're asking for if you could put a condition that he can drive for the limited purpose of driving to and from work. In regards to first offender, we are asking for first offender treatment. He does not have any felony convictions. I understand that he has an open case in DeKalb, but that is an allegation. He has not been convicted of anything. Obviously, he is pleading not guilty because that case was supposed to be going to trial, and he is planning on fighting that case. I think he has a private attorney on that case. So we are asking to accept the plea as negotiated, with all the conditions except allowing him to drive to and from work and for him to be treated as a first offender.
Okay. Mr. Miller, who's your lawyer in the DeKalb case?
Thomas Robertson.
Okay. And I didn't hear in the list, and Ms. Jackson didn't list every cycle you've had, but how long ago was the alleged armed robbery?
I believe that was about 2 years ago.
Okay, but it's now been indicted and it was something that was going to go to trial, but Mr. Robinson got a continuance.
Yes, sir.
Okay, so how long have you been on bond for that?
For about 2 years now, 1.5 years,
Okay.
I believe.
All right. And you have a 14-year-old child?
Yes, sir.
Here in the Atlanta area?
Yes, Your Honor. I'm the primary caregiver other than her mother, but I am the sole caregiver for her.
So does she stay with you, or she stays with mom, or both?
Stays with both, but I predominantly do everything as far as the back and forth to school and taking care of mostly. She has her mom has a newborn, which she's has her hands full with that, so that's why I'm doing most of it.
Where does your daughter go to school?
She goes to Dunwoody High. She's a freshman now.
Okay. And you live somewhere near
I
Dunwoody?
live right down the street from Dunwoody.
Okay. All right. And this construction work that you do, installing seats in stadiums?
Yes, sir. We're based here in Mercedes-Benz Stadium. We also do the basketball stadium as well. I'm pretty much on call for any fixes that need to do through the stadium. We also recently came from Texas and did the baseball stadium. So we go state to state and install any seats you see within the stadium.
So do you travel a lot for work?
Yes, sir, I do. And I have to drive the work vehicle as well once I'm in the other state or wherever we're based.
Okay. How does that work with taking care of your daughter if you're in Texas all the time?
I'm not in Texas all the time. It's just like a month span or 2 month span I'll be there, or it's back and forth. But I'm usually based here in Georgia for the most part. But when I am going out of town, her mother takes over the caregiving.
Okay.
Yeah.
All right. And Ms. Rios says you now have a valid license?
Yes, Your Honor.
Do you have it with you?
Yes, Your Honor.
Can I see it?
Yes, Your Honor.
You can give it to the deputy. How long have you had? I guess I can look.
Yes,
how long
yes,
you've
Your
had it.
Honor. It's been a while I had it now since the situations conspired. I got it right after all the driving while suspended and everything.
It's got a different address than the address on your pay stubs.
Oh, sorry. So sorry, sir. I actually have 2 IDs. That was my old one that they gave me. I have the second one right here.
So do you need this other one?
I usually just keep it in my wallet. Sorry.
Okay. I might keep it for you if you don't need
All
the
right.
second one, just to make life simpler for you.
All right. And I actually did an address change and just held on to that one. So sorry about that.
No, you don't have to apologize, but it will reduce confusion in your life if
Thank you, sir.
you have this one, which matches your address and all that. Okay. Do you have questions about any of the things we've been talking about?
Not at the moment.
I'll ask you again at the very end after we talk about the sentence, but right now, no questions?
No, sir.
Okay. Ms. Rios, we'll talk about Mr. Jackson at another time, but in that case, you're trying to get a provisional license for him?
Yes, so he took his citations down in his disposition, and I thought that the original disposition that didn't have anything about no driving, I thought that would be
We
enough.
fixed that.
Yeah. Oh, we fixed it.
We fixed it. That
Okay.
was a mistake, internal mistake. Originally, there was a condition of no driving. I struck it. But then when we were amending the sentence, it got dropped back in inadvertently. So
Okay.
don't worry about that. But I don't want to go into lots of detail about Mr. Jackson because that's not this case. But you're trying to get him the kind of thing we do in drug court where you get a provisional license that basically says Robert McBurney can go to work, so I can drive to the courthouse and back. I cannot drive to a Braves game to admire the seats that he
The
installed.
DMV just said he needs an order from the judge saying he can drive to and from work.
Okay. Mr. Miller is in a different situation. He has a valid license that would let him drive all over the place.
Yes.
Are you aware of whether there's a way to restrict that so that he can just drive? It's complicated if he's going to be going to Tennessee to install seats. I don't know how that would work.
I mean, I would prefer you just not to have that condition at all. I know that's what Ms. Nix was asking for, because I probably should talk to state court about this, because I'm really not sure how you restrict a license.
Okay, me neither. All right, that's helpful to know. Mr. Miller.
Yes, Your Honor.
You want to be sentenced as a first offender. Tell me why you think that's appropriate, given that, yes, this is your first offense in the sense that you're pleading to it, but it sounds like you and driving for a long time, that was a bad relationship.
Yes, Your Honor. I feel like I should be able to hopefully get this opportunity due to the fact all those situations was when I didn't have my license, which it was suspended, and I was going through registration trouble with the vehicle as well. I do not have that vehicle anymore, and I do have my license reinstated. So I was actually pleased to somehow.
What kind of car do you have?
It's a Mercedes-Benz, sir. It's the same vehicle that I was having trouble with. I actually traded in with my car company, so they understood the problem I was facing. It was an ongoing situation. They have notes within my documents and everything about everything that was going on as far as the registration. So I was able to switch out into the same vehicle, but everything is okay and up to date today as we speak.
Okay. How'd you get the driver's license you had in March of 21 when you got pulled over?
I just think it was a while back. I think it was just a friend that just happened to have ID and just gave it to me because he knew my situation with the driving route suspended, and I kept getting tickets. So it was just something I tried that was a very bad idea.
It was a bad idea, but you had a corresponding social security card. So
I'm not sure about that. So I just got both the social security and the ID from the person, and I'm not sure how that works.
Okay, but this friend had both. Here's a set, a matching driver's license and social security card.
Yes, sir.
How much did that cost you?
It just was given to me. It just was given to me by a friend. That's why I didn't think it was anything was actually real.
Okay. All right. Well, Mr. Miller, I find there is a factual basis for your plea. And I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we've been talking about. Voluntary means no one's forcing you to enter this plea. You agree with both those things?
Yes, Your Honor.
All right. Sentencing you pursuant to the Probation Options Management Act, which means simply that while you're on probation, which you will be for a little bit, if you have a small issue, you and probation will figure out how to address that issue. But if it is more significant, in particular, if you get arrested for anything, that comes back to me. And then you and Ms. Rios and I will figure out how to address that issue. All right. What I'm going to do is follow most of the recommendation from the state. I'm not going to sentence you as a first offender, but I am not going to put any driving restrictions in place.
Thank you, Your Honor.
So for count one, I'm sentencing you to 4 years probation that will run consecutive to count two, which is 12 months probation. Count three is a $100 fine. Count four is a $500 fine. Count five is 12 months probation concurrent with count two. Count six is 12 months probation concurrent with count two. And the state is dismissing count 7 and 8, and they're also dismissing 24 SC 000209 in both its forms. Some special conditions of your probation. Number one, You are to complete 80 hours of community service, and I'm giving you the first 6 months of your probation in which to complete that. I think that is it. The no contact was with the person whose identity he had assumed?
Yes.
All right. I'll leave that out. Covered the fines. So that's it. So it's basically 5 years probation, some community service, fines, and we'll see how that goes. You're going to need to be thoughtful. Yes.
I'm sorry. I apologize for interrupting.
No, it's okay.
Did I hear you say 12 months probation followed by 4 years probation?
Yes, ma'am. Is that a problem?
Yes, it will not be supervised by felony probation until after that misdemeanor probation is served.
Okay, that's not what we want. So let me check one thing. The identity fraud is for the max.
No, 10 is the max, I believe. I structured it this way so that to include the no driving just for the first year.
Got it. Okay, so if I'm not going to do the no driving, then I could just do 5 years probation on count one and run everything concurrent with it. Because I think 5 years probation, I would like to have that, because just so you know, Mr. Miller, if I see you in 6 months and it had anything to do with you not driving the right way, that's gonna, will be revoking time. And so it's good to have 5 years to work with. Ms. Nelson, it's 5 years to serve on count one. Everything else is the same, except that 2, 5, and 6 run concurrently with count one. Thank you, Officer Evans, because that would have been super confusing for Mr. Miller, because he'd be reporting to one probation office for 12 months and then having to shift to the Department of Community Supervision.
Yes, Your Honor. And I just also wanted to touch base on one other thing. I know that you said that Mr. Miller would not have any restrictions for his license. However, I do want to remind Mr. Miller that when he is on felony probation, he is not able to leave the state without a travel permit from probation. So
That's a great point. Thank you. And
clear.
Great. I'll cover that with him in just a sec, but that's a great point. That actually has nothing to do with your ability to drive. It doesn't restrict your driver's license, but while you're on probation, it is okay to leave the state, but only by getting permission from probation first. And I usually have to sign something. So what would be real complicated would be if you have to go to Texas once a week. That is harder to do because each time you leave the state, you need permission. If you got an impressive gig with the seat company where you're going to be in Indiana for 2 months, that is easier because you need approval one time because you're going to be there for 2 months. It doesn't affect how you can drive, other than were you to drive into Tennessee, you're technically violating your probation because you're not supposed to leave Georgia without getting approval from your probation officer first. So what you're going to want to tell your employer is life will be simpler for you if you get Georgia-based projects, but doesn't mean you have to quit your job because your boss says, hey, we're going to be in Alabama for 2 months because there's a new stadium in Birmingham. Just make sure you get approval before you go to Alabama. Does that make sense?
Yes, Your Honor.
Okay. What will be a bad development for you is if you're checking in with your probation officer and your probation officer notices in the background, is that the Gateway Arch in St. Louis? Like, oh yeah, I'm in Missouri working, and you hadn't talked to them about that.
Yes, Your Honor.
Okay. Thank you for that, Officer Evans. And in fact, it's your turn now. Can you give Mr. Miller reporting instructions?
Yes, Your Honor. Mr. Miller, what is your current address?
2327 Dunwoody Crossing, Apartment A, Atlanta, Georgia, 30338.
Okay. And that's Fulton County. Is that Fulton County?
DeKalb.
DeKalb, that's why I asked. Okay, you're going to report to the DeKalb County Probation Office. Oh, let me get your phone number. I apologize.
Yes, ma'am. It's 314-827-7727.
Okay, I will call you following this hearing and will provide you the address to the Dunwoody Probation Office. But you're gonna, I mean, not the Dunwoody, the DeKalb County Probation Office. You're gonna report on July 9th, 2024 at 10 a.m. Failure to do so may result in a warrant for your arrest. Do you understand?
Yes, ma'am.
And I will also provide these said instructions via text and also call you with them as well.
Thank you so much.
No problem. Good luck to you.
Ms. Nix, anything else in Mr. Miller's cases?
Yes, sir.
Anything else, Ms. Rios? Thank you for your email. It's helpful to get that stuff. Mr. Miller, you are 32. Time to not goof around with other people's IDs. You got a 14-year-old daughter and a good job, so just be smart about your choices. Obviously, this is a cab situation is super serious. I know nothing about it. You got a good lawyer. Armed robbery takes you out of commission for a decade. So I hope that goes well for you.
Thank you, sir.
Make sure you show up for court on that one.
Thank you, sir.
All right.
Thank you for everything.
You bet. I think all we have left is Ms. Cosby, who's been waiting patiently all morning, and then Mr. Williams. Is Mr. Williams contested, or it's a let's just talk about it, or TBD?
We'll talk about it. There's one, I need to talk to him real quick.
Okay. Well, why don't we handle Ms. Cosby now, and we'll figure out Mr. Williams.
And Judge, for Ms. Cosby's plea, we've done the paperwork. Mr. Tranter is actually going to stand at the podium.
Ooh.
To be here.
And he's got the third year practice act all locked in? Good. Do you all want to start? I don't know how noisy it is to do what you need to do. Hey, Jekka, nice to meet you. Why don't you get started? Yeah, just because he was explaining it's not like a 5-minute process. We're good till 2, but at 2, I have a civil hearing. So it's all right. They know that they may need to wait a little bit, but why don't you get started? Okay. What was going on out there? And they weren't loving each other. The families. Okay. Everyone okay? Did anyone have to go into custody? Good. We just got them out of the building. Nice work.
Yes, Ms. Rios is back there, and then I have a Thank you.
So Ms. Cosby, you can come on up to the podium, please.
Yes.
All right, Ms. Rivers, you ready?
Ready.
Great. This is position 6, 24 SC 000-852, State versus Ms. Cosby. Shantarian Cosby is here. Can you spell your name for the record? This will be the first time that Ms. Rivers is putting it in.
Yeah, Jacob, Jacob, Tranter, Tranter.
All right, Ms. Tranter is here representing Ms. Cosby, and we have Ms. Nix representing the state. Ms. Cosby, Ms. Nix will put you under oath, and then you get to answer all those questions you've been listening to other people answering, but it's your turn and it's your case. If at any point you want to talk with Mr. Tranter privately, just let me know. You can step away from the microphone, or you may have questions for me, but you'll need to be vocal about that so we can answer them, okay?
Okay.
Thank you. Ms. Nix?
Thank you, Judge. Ms. Cosby, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your true, correct, and legal name.
Shantarian Cosby.
Please spell your name for the court reporter.
SHANTERIAN, last name COSBY.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No,
Is there a medication that you normally take that you have not taken or been given today?
no.
How old are you?
22.
How far have you gone in school?
Some college.
Is English your native or dominant language?
Yes,
You understand that you've been charged with the following offenses, aggravated assault?
yes,
Do you understand that you have the right to plead either guilty or not guilty to this charge?
yes,
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
yes,
Have you had the opportunity to review your rights with your attorney?
yes,
Have the time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to this charge?
yes,
Do you need more time to discuss the case with your lawyer, either Ms. Wood or Mr. Tranter?
no,
Are you satisfied with the services, the legal services you've received from the Public Defender's Office?
yes,
Mr. Tranter, do you waive a formal reading of the indictment for purposes of the plea?
Yes.
And do you waive any and all defects in the indictment for purposes of the plea?
Yes.
Ms. Cosby, do you remember having been arrested on this charge?
yes,
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
yes,
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? The state will reduce the charge to disorderly conduct under OCGA section 16-11-39 and recommend a sentence of 12 months probation, that she have no contact with Mario Andrews,
yes,
and go off the record for a second. Lacey, the option, I gave you the option of either community service or anger management. Which one does she want to do?
Community service.
Okay. We can go back on the record.
Okay, back on the record.
And 20 hours of community service.
yes,
Do you understand that the court is not required to accept the state's recommended sentence?
yes,
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
yes,
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you are expecting today, that you have the right to withdraw your plea of guilty?
yes,
Are you currently on probation or parole anywhere?
no,
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
yes,
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
yes,
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
yes,
Do you understand that you are not allowed to possess or use a firearm while on probation?
yes,
Are you a United States citizen?
yes,
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
yes,
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
yes,
Is it your decision to waive these rights and enter a guilty plea today?
yes,
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
no,
Is it your decision to enter a guilty plea because you are in fact guilty?
yes,
How do you plead to the charge of disorderly conduct in indictment number 24 SC 000852?
guilty,
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
yes,
Do you understand that you have only a limited right to appeal this guilty plea conviction?
yes,
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition? And since this is a misdemeanor, you have only 12 months from today to do so.
yes,
Judge, had this case gone to trial, the state would expect the evidence to show that between June 19th and 20th of 2022, while in Fulton County, officers responded to a domestic incident. The defendant and her mother stated that Mario Andrews had struck them. Mr. Andrews then told officers that Ms. Cosby chased him with a knife and putting him in fear of violent injury. The victim, Mr. Andrews, has other domestic violence cases pending including one from that same night. That case is pending in state court. He has other cases pending, other felony cases pending in Superior Court. What the defendant's conduct that evening was not appropriate, but we understand that there was kind of a lot going on, and so that is why we've decided to reduce the case to a disorderly conduct.
Okay.
And the defendant has no criminal history.
All right. Thank you. Ms. Jackson, Ms. Nick says no criminal history for Ms. Cosby. Do you agree?
Yes, Your Honor.
All right. Thank you so much. Mr. Tranter.
Good morning, Your Honor. Ms. Cosby is 22 years old. She did finish high school. She had some college experience at Clayton State and Georgia State as well, I believe, where she studied communications. She has no prior criminal history. She has 0 kids. She did work at the airport before this incident, but has lost her job because of it. And since her release, she has been working as a bartender at different events. Your Honor, we ask that the court accept this plea as negotiated. And we would also ask that the probation fees for Ms. Cosby be waived.
Okay. Ms. Cosby, how did you know Mr. Andrews at the time? Was it a boyfriend-girlfriend situation or a roommate? Pardon me?
Not my boyfriend, my mama's boyfriend.
Oh, Mr. Andrews was your mother's boyfriend. Okay, got it. I missed that piece from the recitation. So he was close to your mom. You were in the household at the time. Got it. And is he still close with your mom?
No.
No? Is he out of her life or he sometimes pops back up?
Out of her life, I believe.
Okay. Do you and your mother live together?
Yes,
So you would know, I guess, if he's showing up.
sometimes.
He shows up.
I would know sometimes, but I don't be at home all the time.
Okay, you're other places as well. That's all right. When's the last time you saw Mr. Andrews?
It might have been a little bit after the accident.
Okay, but that was 2 years ago, so it's been a minute. I'm asking because I want to make sure it's going to be easy for you. One of the conditions of your probation is that you have no contact with him.
Yeah.
And if he's around your mom and you live with your mom, that's not going to work. He'll either have to go away or you'll need to live somewhere else. And I don't mean for you to have to move. That's why you need to be straight with me. Hey, you know what? Actually, he's around a lot. Because if he's around a lot.
No, he's not around a lot.
Okay. All right. So it's possible for the next few months, he might not show up at your mom's house at all.
Yeah.
Okay. All right. Ms. Nix, you mentioned that he has his own DV case from the same night. Is Ms. Cosby the alleged victim or Ms. Cosby's mother is the alleged victim?
Her mother.
Okay. So it was just pretty crazy in that household then. Got it. Okay. So you lost your job at the airport when you got arrested for this? That was 2 years ago. Have you not been able to get a job back at the airport or because?
The airport don't do felons at all.
Okay, and because that was an open charge, they just said, sorry, it's not going to happen. You're resolving this with a misdemeanor. Does that mean you can go back to the airport or what do you plan to do?
I mean, I should be able to.
Okay, are you interested in going back to the airport or are you going to do some other kind of work?
I'm going back to the airport probably.
What were you doing there?
Working. Just doing like little restaurants and stuff in there. It just depends.
Okay. But you bounce from restaurant to restaurant or you were like the Nathan's hot dog lady?
No.
No, different place.
Yeah.
Okay. All right. Do you have any questions about anything Mr. Tranter said, Ms. Nick said, or I said?
No.
All right. Well, Ms. Cosby, I find there's a factual basis for your plea. You're pleading to disorderly conduct. My guess is that your mom and Mr. Andrews were probably disorderly that night as well, but this is your case and not theirs. I also find that your plea is knowing and voluntary. Voluntary meaning no one's forcing you to do this, and knowing meaning you've understood all the things we discussed. Do you agree with that?
Yes.
Then I'll accept your plea. Mr. Tranter, is it all right if someone from my office signs your name to the indictment?
Yes.
Ms. Nix?
Yes, sir.
And can we sign your name, Ms. Cosby?
Yes.
All right. I am going to sentence you, Ms. Cosby, to 8 months of probation to the reduced charge of disorderly conduct. During those 8 months, no contact with Mr. Andrews. Don't reach out to him. Don't Instagram him. If he shows up at your mom's house, you gotta leave the house at that point. Hopefully he doesn't move in. But if he just drops by to say, hey, I'm here for a sandwich, you need to not be there while he's having that sandwich, okay?
Okay.
And tell your mom that, because if for whatever reason she wants to spend time with him, she needs to know the impact it has on you. Okay, it's not your mom in court today?
Mm-mm.
Okay, all right. And you'll need to complete 20 hours of community service.
Okay.
I'm gonna waive your supervision fees for the first 2 months because you may be able to get back to the airport. And I assume that is steadier work and thus more money for you than bartending, although maybe you're killing it bartending. Not so much?
I ain't gonna tell you all that.
All right. You actually don't not get to tell me, but I don't care, so I won't press it. Mr. Tranter, anything else on behalf of Ms. Cosby?
No, Your Honor.
Ms. Nix?
No, sir.
All right, that's it. Thank you.
Thank you, Judge.
Nice work on your first plea, Mr. Tranter.
I know.
You're on a roll. All right, so Mr. Shapiro, you're still here because you've got the Williams thing?
Judge.
All right.
Thank you.
Okay. Yeah.
What are you asking for?
Mhm.
What are you asking for? What number?
Welcome and
How much time?
it's like a year.
Is that what's left?
When it was all declined, the drug, he got people from the drug case.
Okay.
Decline
Oh, is this the case that it was like changed to children?
Yes.
Okay.
Yeah.
That's what I'm talking about.
Conversation.
Yeah.
Yeah.
I'm being nosy.
Oh, I was just gonna ask, like, okay, so he's been in for like 4 months. Thanks, there's two additional months and then terminate the balance. And then he's still not processed the other case. Because he's already been in for like 4 months, so that would be.
So I'm definitely not gonna no process other case, just then close them out.
Yeah. They're supposed to come in and start setting up. They can. I've asked them to.
Tuesday, Wednesday, Thursday.
He has, I think, a year and a half.
But yeah, I'll be in touch with you.
Oh, year for 8 months?
Have a good weekend.
I thought that he only had a year.
Yeah.
I would definitely be more open to doing a year and closing it out than doing 6 months and closing it out. He has. One year, 8 months and 7 days.
Okay, and you, and if we don't agree, you will not have process that other case.
Right. I mean, he's getting the benefit of that. He's gotta do something.
All right, one more moment,
Okay,
Judge.
No problem.
That's what fun feature are they doing on you? Or am I allowed to know?
It is a BBC documentary about the election interference stuff.
Wow.
So they've been talking with lawyers and this and that, and my colleague can't really talk to them a whole lot. But I can, because my part's done.
International now.
There you go. Global. So next week we're back at it. Monday, you guys don't have anything here. Tuesday. Is Mr. Jordan back next week? Because he's got a motions hearing. Are you gonna have to do
Back
that?
next week.
Okay,
Not that I know of, I'm not stepping in on that.
all right.
I'm right here.
Oh, we didn't. Oh, I know. I swear back or not.
Drug court.
I thought he was back there too, so I didn't see him. He must have snuck out the other day.
Yep, busy. All right.
Laura Bird. Yeah, I gotta try to fix them again.
Okay.
They're supposed to call me back. The
Is that a
manager.
rust?
It's a restaurant.
Okay, I thought that.
Yeah, the manager's supposed to call me back and forgot about it.
So the only reason I know I keep like blowing you up about it, I just don't want that acceptance letter
Yeah.
to expire. That's the only reason.
So I'll try her again today.
Okay, thank you.
About like, oh, I like, if it's, I need to get information from someone else, usually I will do that right when I
Totally get
get
it.
that information, and then I'm like, I will do it, I'll get back to it when that person gets back to me, and then if they don't get back to me.
I totally get
Mr.
it.
Shapiro,
Yes, ma'am.
could you check your email for me, please?
Sure.
Thank you.
Yeah, we were aware of that. How many previous revocations total do we have, Officer Evans?
Let me see.
I counted 3, but one was also an amended order, so I'm just trying to figure out.
Then for it to not happen within all this time.
Yeah. You have anything coming up?
Not a year, got a immunity motion on Monday in Florida.
Fun.
Yes. And then there's a base certification hearing. I don't know.
4. All right, thank you, Officer Evans.
I'll send you a copy of those.
Okay, thank you.
No problem.
I just got arraignments and then just these are arraignments.
Is there no July trial calendar with the
Oh, yeah.
conferences going on?
Oh yeah, we got one on, it's the second.
Oh, okay.
But it's all like non-victim cases.
Gotcha.
that I got, so it's a little easier. It's just law enforcement. There's like an Agasaw law enforcement that was the only like
some trafficking.
That's everything else trafficking.
Mhm.
Oh, yeah.
Are those all co-defendants? Oh, wow.
These two are. That one's not. That one has a co-defendant, but he's in the wind. So.
Are any of them good?
This one's okay. It's pretty good. I mean,
Okay.
it's search warrant. It's just identity is a little bit of an issue. This one should be good, but we had a suppression hearing and the facts are pretty straightforward, but the officer did not do very well testifying. He couldn't remember if the guy had case lanes left or right. He said one thing on the stand, another thing is report. So,
Yeah. Is she the C3 attorney here now? Oh, okay.
And then this one's actually pretty interesting. I don't really want to try it, but might have to.
just because it's kind of complicated because the officers came on a DV and then they took him to the hospital and found all this drugs.
Really? They took him to the hospital? Because he was the victim?
It was kind of a mutual.
Okay, interesting. Oh, yeah, that one.
Another community hearing, but not till the middle of the month.
Okay.
We are going to.
No, if he closes out everything.
Yeah, that's what we're doing. You said you were working the year. I'm confused.
On the technical stuff. Pardon? Sorry, okay. If he lets us close out everything, I'll get on that case, and then he's all done, and then we don't have to worry about
Yeah.
getting picked up on everything.
You're just spectating?
Yeah.
You're always welcome, and here's public space. Well, when you show up, there usually is, but maybe not today.
It has, I looked up GBI,
It hasn't tested it yet. Okay.
Because I thought we were revoking the year, terminating the balance. Because I thought.
We got one thing left, and then we're done for a little while.
Year, terminate the balance, and then you decline the.
Is it just drug possession? There's nothing like.
I think it's drug and drug objects, something like that.
Are people from your team going to NACOM, the thing in New Orleans, the Court Administrator Conference? I'm presenting. Yolanda Lewis and I are. Well, all right. It's in the morning, you'll have to be up. Yeah, here in New Orleans, that's not easy to do, to show up. Yeah, we're one of the first presenters. I gotta be back here.
He's been.
How long does it go?
But then he's done. Then he's done.
So Mr. Williams is right here. Are we ready to go with Mr. Williams?
Yes, sir.
Well, I know you're ready. I'm wondering if they're ready.
We had a miscommunication. We're working on it.
Okay, all right. So are you going early or you'll just be? Yeah. We got a minute. You want to go in the jury room?
He's got it.
All right, I'll see you over there.
You do that in jail?
No. He has to do the evaluation once he gets charged.
Yeah. Well, how would you do the evaluation
But he's
either
supposed to
way?
get treatment. That he's gonna have to do the eval if he ever wants to get discharged from the registry.
Okay.
But if we close it out, then it's done. It's like, you know what I mean?
Yeah,
If
well,
it's-
that's what we're asking for it to be closed down, like revoke the unit and terminate it. That's what I explained to him. Because he already thought he was getting out because we were waiting for 4 months, and I was like, he's gonna have to do 8 more months.
I'll revoke the year and continue him, and I will decline the drug case.
Continue him
for the remaining 8 months to make sure that he does the eval treatment. How do you feel about that?
I think that's it.
Okay.
So he had a miscommunication. He didn't realize, he thought he was not saying that he was going to decline if he only does a year instead of 18 months. So this is a new agreement. He wanted to do the evaluation and treatment for your sex registry, because if you do that, eventually you could probably, I think, he's saying eventually you can get off the sex registry if you do evaluation and treatment.
How long is he been?
10 years. Oh, no, left 18 months. So the agreement that he's saying now is revoke a year, and then not terminate, but just work a year and use the remaining time for him for evaluation and treatment. And he's going to dismiss the other case. And he's saying that he has to do
Right.
off the registry. Yeah, okay. Yeah. So that means, this is what that means. We'll still have to do the 8 months. He's revoking a year. Instead of terminating, he's gonna ask for the balance to be reinstated until you can do the evaluation and treatment. Because if you do those things, you have to do those things to ever get off the registry. So then you send that remainder, which would be 8 months left to get that stuff done. And then, but you still gonna dismiss the new case. You understand? Be in for 8 months, maybe. Once you're out, get the evaluation and treatment. That other case goes away. You just make sure you do that. Make sense? Okay. So the rate was stipulating to everything. But I'm gonna still explain that.
I know.
We don't know. He can't tell you that. You just have to see what the judge is. Okay, we're ready. Oh, he's gone. I'm who I'm talking to. You have to get that evaluation and get out though. That's the only way you're gonna get off and be done with this, because they're gonna keep trying to revoke you even with those 8 months left. After you've already, even with you, after you're done with those 8 months, let me get the math right. 18 months minus 1 year is 6 months. So you have 6 months after you get out that you'll still be on probation, that you have to get all that stuff done, the evaluation, treatment, GED. That's what you do. And when you get that done, with it, then you'll be good for when you, the paid probation ends. Sure, I'm clear. Okay. And anything that they say that you don't understand, just ask me and we'll make sure we hone out everything. Why did Jacob leave?
I'm sorry?
Why did Jacob leave?
Ania.
Yeah. Oh. Where are you gonna live? Address.
Okay.
Well, I mean, he's asking where you can live.
Right now, I'm in the bridges. And that was okay to share office was, I can't remember that his name, but it's Preston.
Yeah.
And it's bridge right there.
Yeah.
So there's no.
Okay.
Court come to order.
All right. Ms. Nix told me that you all have sorted something out for Mr. Williams, but it looks like maybe not.
Okay. If you can do that, that would make me feel a lot better.
Let's go on the record. May we?
Yes, Judge.
Great. Ms. Rivers, are you ready?
Yes, I'm ready.
Great. We are here on 16 SC 140879, a case from way back when, Demario Williams. And I have a warrant, probation warrant that I signed in October of last year, sworn out by Officer McKinney, that alleges that Mr. Williams, who's not supposed to be around kids, was around kids, and that was pretty frequent. There may be a couple other issues. It's kind of hard to read the warrant because of the notary stamp, but there's a sex offender registration concern as well and treatment. I want to get this on the record and then I'll turn it over to Mr. Shapiro. Officer Evans was able to share with me that Mr. Williams has 1 year, 8 months, and 7 days remaining. So he's almost to the end of this sentence. I'm going to want to understand what else is out there given the registration requirement. But it sounds like there's been some good shuttle diplomacy between Ms. Rios and Mr. Shapiro. Why don't you start, Mr. Shapiro?
Thank you, Judge. So this is a 2016 case in which Mr. Williams entered a negotiated plea of guilty to 4 counts of cruelty to children in the first degree and was sentenced to 10 years of probation. The original offense was a sexual offense in nature, but was ultimately through negotiations between the state and the defense reduced from child molestation to child cruelty. And so as a result of those negotiations, Mr. Williams was, in addition to some other conditions, required to register as a sex offender and required not to be around anyone under 16 years of age. So as the court's already seen from the warrant, Mr. Williams now has a new arrest on a felony drug possession case. Ms. Nix and I looked into the status of that case. It appears that the substances that were found on Mr. Williams at the time of his arrest have not yet been tested by GBI. And so we don't know what substance or in what amount just yet. However, he does have the new arrest. In addition, and sort of more importantly for the state's concerns, Mr. Williams, though a registered sex offender, was found to be around minor children, as is described in the warrant. I understand from speaking with Ms. Rios that Mr. Williams is indigent and has issues with homelessness, and at the time was, I believe, visiting a family member, and that the children were brought over to the house without Mr. Williams' knowledge. Again, the complications of adhering to the requirements of being a registered sex offender when someone is also, struggling with housing does make that a little more complicated. But the bigger issue, I think, is that Mr. Williams has now been revoked several times for failure to undergo a failure to undergo sex offender treatment. It requires that he be assessed and that he comply with any recommended treatment. Also, a technical violation is that he has failed to obtain his GED and provide proof to DCS of. And so, Judge, what the state has discussed with Ms. Rios, it was my understanding that probation's recommendation was going to be to revoke the balance of his probation and simply close him out. I discussed with Ms. Rios that I believe we have a stipulation to the technical violations. The state will be declining the unindicted drug case, and Mr. Williams is going to be serving a year in custody and then continued on probation. The importance of continuing him on that probation is to ensure that he undergoes this assessment and this treatment before the end of his probation. And so I think that's the agreement we have. Any of that incorrect, Mr. Rios?
That's correct.
Okay. So you answered the first question that was going to come up, which is why then leave 8 months and 7 days remaining. I get it. That makes sense. I think what I'll do, and I'll hear from Ms. Rios on this, assuming I go along with this, is modify the remaining probation to say you must get that evaluation. Is it first an evaluation and then treatment?
It's an evaluation and then compliance with any recommended treatment.
Okay, so it's the usual in the context of drug and alcohol abuse treatment if recommended. It would be an evaluation to see if any treatment or counseling is appropriate, having had the sex offender evaluation, or whatever.
That's my understanding from having looked over the guilty plea transcript. There is separately just sex offender treatment. I'm aware of some centers that specialize in providing just sex offender treatment without the need for an evaluation, but that was my understanding from reviewing Mr. Williams' case.
Okay. So then what I may do is, what I will likely do is modify his probation to say within the first month after you're released, you've got to have that evaluation because there's not much time left. If it's just you've got 8 months to get the evaluation and gets around to it in month 7 and they say you really, really need treatment, we don't get much fidelity to that treatment. This is a first offender disposition. You are not seeking to change any of that? So Judge Downs sentence.
I was unaware that it was a first offender sentence, Judge.
Yeah. It doesn't change anything for me. I see that it's first offender. I just want to make sure you were aware of that, but it sounds like you're okay with your recommendation. I mean, a year's revocation is significant, no matter how you slice it.
That's fine, Judge.
Okay. So I'm wondering if somewhere maybe in one of the probation revocation orders, the original disposition, the conditions are register, no illegal drugs, cannot be around kids under 16, problem there, obtain your GED, and then Judge Downs said, I'll think about suspending this if things go well. Things didn't go well, so I'm not worried about that one. Where did you find the hook for you need to have an evaluation?
So there's an August 17th, 2023 revocation order. It's actually, I think, titled the second amended order of revocation, in which Judge DeFore revoked 90 days and then reinstated the balance, and under the other special conditions said reinstated under original conditions, 30 days to provide assessment to CSO.
Okay, I see that. Let me. But that is previous conditions remain the same. So there's an order Judge Cottle signed in May of 2019 that says revoke the balance of his probation.
I think that was later amended, Judge.
Well, I hope so. Let's look. Yes, it was amended to just revoke a bunch, but not the balance, and then reinstate it.
The 2 years and 11 months?
Yes, sir.
Okay.
Yep, that was amended. Oh, in big letters at the top, amended. Okay. Ms. Rios, what, if anything, do you, I'm inclined to go along with this. You don't have to guess. What do I need to say? Your thoughts?
Yes, Mr. Williams, at this point, he's been in for 126 days. We've discussed and he's fine. And he did say it's just been really hard being homeless to get these things. He did go and start the process of getting his GED. He went to Atlanta Tech, and he said he tried to call the probation, but he doesn't have access to a phone call. That's why he was told to actually find a phone so he could call his probation. That's why he went to his grandmother's house. His mom has just passed or recently passed. His sister passed away. So the only option was his grandma, and he didn't know his aunt was going to show up there with the kids. That actually happened when he was upstairs, showering and getting dressed. So we're asking, I mean, of course, he would not like to spend more time in jail, but he understands, especially the exchange for the new case being dismissed. And with that, keeping his first offender that way, that he already has odds against him with being homeless. At least he won't be a convicted felon and can try to go to school and get a job. So we're asking for you just to agree to what we've negotiated.
Mr. Williams, I was going to ask if you've got family around, but I've heard some of the answer. You had some family around. Tragically, you lost your mother and your sister?
Yes, sir.
What happened to your sister?
my god cousin had a baby shower and she was around to break the fight up, but I was in prison at the time when this happened. And once my sister was breaking the fight up, the girl who had the gun, who my brother and my godmother going to court for, tried to let her go for putting the trigger on my sister, and she was in a breathing machine, and she was in I think they call it it's a word for it, but
She eventually passed.
Yes.
Okay, someone shot her.
Yes.
Okay. Your grandmother is still around.
Yes.
Okay, when you get out, where would you plan to stay? Would you start at a shelter, or what would your plan be?
Shelter would be fine, but like I was telling her, that since I told my PO that I was up under the bridge near Langford, about the expressway, that was the only place that I gave the address to her, and everything was complied to it. It was my grandma's address at first when everything was approvable. But when she came there, she saw nothing around, and when she told me to FaceTime her on Google Meet, she heard background, so she was just realizing there was
a situation there.
Yeah.
Mr. Shapiro, is it your read of the final disposition that Mr. Williams's requirement to register expires with the end of his sentence? It's not a statutory requirement that he's registering. It was imposed by Judge Downs, maybe negotiated by the lawyers, but at the end of his sentence, he's doesn't have to register anymore.
That is my understanding, Judge, and I was just finishing my review of the plea transcript, and that was what was explained to Mr. Williams at the time he entered his plea, was that if he successfully completes first offender probation, obviously he no longer has a conviction, and as a result of no longer having a conviction is no longer required to register.
Okay.
I also did not see any mention about the assessment and the treatment, so I don't know if that was imposed as a condition as a result of a later revocation.
It must have. I've looked at the revocation orders and none of them modify probation, but Judge DeFore does say that you need to go do that. So I haven't read. I don't know that there's a transcript associated with his, because the revocation transcripts I see are from 2019. So I don't know the origin of it other than that's what's in there.
I think the best outcome would be to have Mr. Williams evaluated and treated if necessary, but that at the end of all of this, if he could have no felony convictions, and I think that would likely be the best outcome for everyone.
Yeah. All right. Mr. Williams, do you understand what we're doing today? Your lawyer on your behalf is stipulating to, which means basically agreeing, this not requiring the state to prove it up, that you violated certain aspects of your probation by not having gotten your GED. Just explain why. And being around kids when you weren't supposed to be around kids. Again, she explained why. And maybe you violated a condition, although we can't necessarily put our hands on it, that you were supposed to get an evaluation, a sex offender evaluation. Do you understand that?
Yes, sir.
Okay. It also sounds like the state is not proceeding on the charges that arose when you got arrested. The allegation is that you had some drugs on you. I'm going to ask you a question that I need you to be honest with me about. It's not going to get you in any more trouble. Do you struggle at all with using illegal drugs? Do you feel like maybe you've got an addiction to whatever it might be, pills or cocaine or marijuana or anything like that?
No, sir, because I don't even use drugs at all. But like I was explaining to the officer, that it was already in the pants that I put on when I walked a friend halfway to the house because he was scared of coyotes.
Okay, and we don't need to, I want you to get into the facts and circumstances. I asked more so to make sure we're lining up the help you might need. But you're telling me that while you're struggling with being unhoused and things like that, you don't struggle with any kind of addiction to drugs. Is that a true statement?
Yeah, because I don't use drugs.
Okay, then you don't have an addiction to drugs. All right. Okay. All right. Mr. Williams, I find through your stipulations that you have violated the terms and conditions of your probation. I am going to revoke 1 year of your probation. You will get credit for the time that you served, and I'm going to suspend the balance. So when you are released, you're done with probation. You're going to have a lot you need to work through, but you won't be under sentence anymore, which means it will be easier to find a place to live and move forward in the way that you need to move forward. You will not have had that evaluation that Judge DeFore thought you needed to get, and I understand why Mr. Shapiro thinks you should get. There may be counseling you need to get. You're going to want to avoid getting into a situation like this again. It won't work out the way it did last time. It's been a difficult sentence for you in that you've been revoked a few times, but you're going to need to figure something out differently, because if you get arrested again for the kinds of things that initially got you in trouble, not even Ms. Rios would be able to get you a probated sentence again. You understand that?
Yes, sir.
Do you have any questions about what we're doing here?
I do have a question, but I don't have a question about,
Why don't you ask Ms. Rios the question first, and then she'll let you know if it's something for me.
what
No, because we don't know if they're gonna do 2,500 or not, so we don't have a release date. So we can do a release date based on the 8 months, but it could be less, so we don't know.
He doesn't have a question for you, Your Honor.
Okay. Because your revocation is a year, you may go back into state custody. You may not stay here in the county jail. You understand that?
Yes, sir.
Okay. Mr. Shapiro, anything else?
No, nothing from the state judge.
Ms. Rios?
Your Honor, would you mind putting it on the record of the dates that, how long he's been in custody? I don't know if that.
Sure, because Officer Evans is going to need to include that. Let me see what oops, wrong direction.
Your Honor, I have an in custody date of January 13th, 2024.
Yes.
Does that sound right to you, Mr. Williams? You remember when you got arrested?
Yes, sir.
I've got the same date, January 13th is associated with the booking number. So yes, ma'am, it would be credit from January 13th of 2024.
Yes, Your Honor.
All right. Officer Evans, do you need anything else?
Nothing further, Your Honor. Thank you.
Okay. Ladies and gentlemen, I think that completes our calendar for this morning. Any other add-ons I don't know about? No? Okay. Thank you.
Marcus Jackson.
Yeah, we don't have to talk about that on the record, though.
Okay.
I can let folks go.
Yes.
Thank you, Ms. Rivers. Thank you, Bridget Jackson. We're talking about a different Jackson. And thank you, Officer Evans. Today was just a one-time thing. I am now, we don't have Ms. Tucson anymore, so we are hoping to get a full-time assignment.
Yes, Your Honor. I was just covering today. I know I'll be back on the 27th, I believe.
Just doing.
Okay. Well, we're happy whenever you're here.
Thank you, Your Honor. Have a great day and a great weekend.
Same to everyone else. Bye-bye.
Thank
Okay,
you.
have a
Bye-bye.
good weekend.